Here we go. All right. All right, let's go on the record. We are now in day 3 of this jury trial. All the jurors have reported and are available. The state is ready to call us next witness. Anything we need to take up before calling on the jury, Ms. Russell? All right, Ms. Fagan?
The only thing is that I wanted the court to know that we aren't going to move forward with the witnesses so we can release Dr. Geller and Detective Nelson.
All right.
I already let Ms. Russell.
Well, she told me by email, so all the research I did this morning. No, it's part of the job. All right. You can convey that to your witnesses, understood, and we will move forward. So does that change your anticipation of the timeline for this morning of you have other witnesses to present, I presume?
No, so we were discussing it. We do expect to do closings today.
Okay. All right. Do you anticipate putting up any of the other witnesses on your list today?
Witnesses.
Okay. All right. In that case, thank you for letting me know, and we'll work probably into the charging conference this morning at some point. If we can bring in the jury.
Come on.
Where?
I'm up there.
Okay. All right. I'm like, and I did it myself. I didn't.
Oh, I can't even say anything?
No, it was my fault. I tried.
Oh, I fell for it this time. It's a night.
I got it right here. Oh, but you.
All right, for the jury.
President County for your honor.
Thank you, Deputy Scott. Welcome back, members of the jury. We are ready to resume the state's presentation of its case in chief. State may call its next witness.
State calls Miss Terry Johnson.
Please go ahead, for me. Do you swear for that the testimony should be in court is the truth and nothing but the truth shall help you?
Terry Johnson, T as in Tom, ERRY, Johnson, JOHNSON.
All right. Good morning, Miss Johnson.
Good morning.
Just tell the jury, generally, where do you live?
Atlanta, Georgia.
Okay. And I'm gonna ask you, do you know the defendant, Airieon Young?
Yes.
Okay. And do you see Mr. Young in the courtroom today?
Yes.
Okay. Can you please point him out by an article of clothing he is wearing?
A black jacket.
Okay. And is he sitting, can you just
Sitting to my left.
Okay. Let the record reflect that the witness has identified the defendant.
The record will so reflect.
Ms. Johnson, how do you know Airieon Young?
He used to be a friend of my son,
Okay. And what's your son's name?
Jabari Johnson.
On April 24th, 2019, Ms. Johnson, had you or did you make contact with a Detective Nelson?
Yes.
Okay. And specifically, just tell the jury why you made contact with Detective Nelson.
I had got a phone call that my son was.
Hearsay.
So
Okay, you got to rephrase?
I'll rephrase the question. Can you, did you at some point see your son on the news?
I saw my son on the news.
Okay, all right. I'm going to show you what's been tendered as State's Exhibit 6. We can publish State's Exhibit 6. You recognize State's Exhibit 6?
Yes,
Okay. Is that the picture that you saw on the news?
yes.
Okay. You publish it? Okay. All right. And can you just point to the jury just right behind you and speak loudly if you say anything? Which of these individuals is your son?
That's my son Jabari right there.
And when you spoke to Detective Nelson or Lieutenant Nelson, excuse me, did you tell her that you knew anybody else in the photo?
Yes,
Okay. And who else did you know in the photo?
I told her I knew Damo.
That's the name that you knew Airieon Young by?
Yes,
All right. At some point, were you aware of your son and Damo or the defendant attending a funeral together?
yes.
Okay. I'm going to show you what's been marked as State's Exhibit A and tendered. You recognize that?
Yes,
All right. Did you what did you tell the police about this particular photograph?
he asked me to show him who my son was.
Okay, all right. So you saw in State's Exhibit 8, can you publish it, please? The redacted one. All right. So, all right. In this photograph, which one is your son?
That's Jabari.
Okay. And did you also notice the defendant, Arian Young?
Yeah.
Okay. And can you just point him out in the photo? Okay. All right. I have no further questions. Thank you.
All right, let's just, for the purposes of the record, the individual she pointed to in this particular exhibit is third from the right. And on the prior exhibit, it was the one, her son she pointed to was on the farthest to the right. Miss Fagan, any cross-examination?
Good morning, Ms. Johnson.
Good morning.
How are you?
I'm good.
Ms. Johnson, when you spoke with police, did your son also speak with police?
Not at that time. I can't remember.
At some point, did he speak with police?
Yes,
And were you present? Maybe not.
I don't think so. No.
Okay. Ultimately, did you want to be here today?
No,
Okay. And were you, did anyone indicate to you that there would be a warrant for your arrest if you didn't show?
well, yes,
Okay. And so initially, were you told to be here yesterday?
yes,
And, were you aware that there was a warrant put out after you didn't show?
no,
Thank you, ma'am.
Can you redirect?
No.
Can this witness be excused?
Yes.
All right, thank you, ma'am.
thank you.
Say, may call next witness.
That calls Sarah Van Home. Okay. Excuse me.
Okay. Do you swear or affirm that the testimony should give a court?
I do.
Please state your first and last name in court.
Yes. My name is Sarah. That's Sarah with an H. Last name is Van Holm, VanHolm, and that's 2 words.
Okay, thank you. All right, Ms. Van Holm, how are you today?
I'm good.
Traffic?
Traffic could be better. I apologize.
No, it's okay. Could you just tell the jury specifically, where do you work?
I work at the Georgia Bureau of Investigation.
Okay, and what do you do at the Georgia Bureau of Investigation?
I am a firearms examiner.
And can you just explain to the jury what a firearms examiner is?
Yeah, so as a firearms examiner, primarily we determine if a bullet or a cartridge case was fired from a particular firearm. If no firearm is submitted, we can determine if a group of cartridge cases or a group of bullets was fired from the same firearm or not, and potentially provide a list of manufacturers in which those cartridge cases or those bullets were fired from. We also perform services in serial number restoration and muzzle to target distance determination.
Thank you. How long have you been a firearms examiner?
Since July of 2017.
Okay. And to become a firearms examiner, what type of training did that consist of?
So I have a bachelor's degree in biology from the University of North Georgia. Prior to being employed with the GBI, I was an operations manager for a small firearms manufacturing company. I was a certified firearms instructor, and I was also a competitive shooter as well. Upon being employed with the GBI, I completed a 14-month training program to become a firearms examiner, and that was followed by 7 months of supervised casework. I have been certified as an armorer for multiple firearms manufacturers. I've attended multiple conferences and conventions that are firearms related, and I'm also a member of the Association of Firearm and Tool Mark Examiners.
Can you explain to the jury, do you have any other certifications or besides the ones that you just discussed?
I have no further certifications.
Sorry about that. And can you explain to the jury just a little bit the process of, I guess, receiving a firearms and how you go about that with GBI? Firearms or either cartridge cases, anything, how does that process work?
As far as the examination itself?
Yes.
Okay. So what I'll do, if this is all right, I'll explain what a cartridge is and how that pertains to what we do.
Well, before we do that, let me do a couple of other things. Have you testified as an expert before?
Yes, I have.
Okay. And have you been tendered as an expert?
Yes, I have.
All right. How many times?
70 times.
Okay. And that's in your total career
Yes.
as an expert? Okay. At this time, Your Honor, state tenders Ms. Van Holm as an expert in firearm science.
No objection.
State may proceed.
Okay. Can you just explain to the jury a little bit about what a cartridge is, what a projectile is, what goes into the testing?
Yes. So as a firearms examiner, what we are looking at are the repeating patterns of markings that are imparted on the different components of what we call a cartridge during the firing process of a firearm. Those markings are formed during the manufacture of that particular firearm. So a cartridge is a single unit of unfired ammunition. It's composed of 4 main parts. The main housing being the cartridge case, cylindrical object open in the mouth, sometimes referred to as a shell casing. So inside of that cartridge case is going to be your smokeless powder or your gunpowder. In the mouth of that cartridge case is going to sit your bullet or your projectile. And then on the base of the cartridge is going to be something called a primer, kind of looks like a button. When the trigger is pulled on a firearm, it releases what's called a firing pin. That firing pin is going to dimple that primer, as you can see here, at a high velocity. And what that does is it creates a spark inside of that cartridge that ignites that gunpowder. And that creates a rapid gas expansion. That rapid gas expansion is actually going to dislodge this bullet from the mouth of the cartridge case and send it traveling down the barrel of the firearm, where this projectile is going to pick up markings from the barrel of the firearm. Well, because of equal and opposite reactions, as it's pushing that bullet down the barrel of the firearm, it's actually slamming this cartridge case into the breech face of that firearm. And it's slightly expanding inside the chamber of that firearm as well. And depending on the type of gun, that cartridge case is actually going to be pulled out, extracted, and ejected from the firearm. All of these interactions with the gun are leaving markings on these components that we as firearms examiners are able to look at under what we call a comparison microscope. So we can compare those markings left, and essentially a comparison microscope is two compound microscopes joined together by an optical bridge. So two microscopes you'd see in a regular high school classroom, joined together by an optical bridge, so we can look at two cartridge cases or two bullets next to each other under similar light and similar magnification.
All right. And specifically, you're looking for markings? Is that what it is?
Yeah, we are looking for repeating patterns of markings that are unique to a particular firearm.
And does each firearm have a specific marking?
So each firearm is going to have unique markings for that firearm, and that comes from the manufacturer of that firearm and also from the wear and tear of that particular firearm as well.
You explained a little bit earlier that sometimes you may not receive a firearm, but just receive cartridges. Can you explain to the jury how you're able to determine what type of firearm fired that particular cartridge or that projectile?
Yes, so if we just receive a projectile or we just receive a cartridge case or a group of projectiles or a group of cartridge cases, we can determine if that group of cartridge cases was fired from the same firearm or not, looking at those markings. And likewise, for those projectiles, we can determine if they were fired from the same firearm or not, looking at those unique markings. Now, if we don't have a firearm, what we use are called class characteristics in order to determine the type of manufacturer that may have fired that cartridge case or that bullet. Now, class characteristics are markings and characteristics that are indicative of the design of the firearm. So a really easy one is caliber. What caliber is the cartridge case? What caliber is the bullet? And different manufacturers manufacture their firearms a little differently, and that leaves marks for us. So on cartridge cases, for example, one of those is firing pin shape. What shape is that firing pin? That can tell us what manufacturer manufactures their firing pins that way. So we can provide a list saying this manufacturer may have fired this cartridge case. Likewise for bullets, different manufacturers rifle their barrels differently. So we can look at that projectile and look at the rifling on that projectile and again, provide a list using a database that provides us the measurements of different manufacturers and how they create their barrels.
Thank you. At some point in time, were you able to, or did you become involved in a GBI case number 2019-101-2252?
Yes.
Okay. Excuse me. And were you able to complete a report in this matter?
Yes, I was.
Okay. And why, just explain to the jury why you write a report.
To report our findings.
Okay. And at some point, were you requested to do some sort of testing in this case?
Yes, I was.
All right. And you did a report, right?
I did.
Okay. I'm going to show you what's been marked as State's Exhibit 14. You recognize State's Exhibit 14?
Yes, I do.
All right. It states Exhibit 14, a fair and accurate copy of your report.
Yes, it is.
Okay. At this time, State tenders State's Exhibit 14 into evidence.
No objection.
Admitted.
If we could pull up State's Exhibit 14, please. May we publish now, Judge?
Okay.
Yes. All right. All right. If we could please start at the, what evidence in this case did you receive?
So I received 10 40 caliber cartridge cases, 14 9mm cartridge cases. I received, let me see if I can- I received 3 9mm bullets and bullet jackets, and I also received various bullet jackets and bullet fragments.
Okay. And where did you receive, let's start from the very top there, on April 24th, 2019. What did you receive from the Fulton County Examiner's Office?
So I received projectiles and projectile fragments and jacket fragments from the Fulton County Medical Examiner's Office.
I'm going to show you what's been marked as State's Exhibit 33, 34. Do you recognize State's Exhibit 33 and 34?
Yes, I do.
Okay. And is that what you received from the Fulton County Medical Examiner's Office?
Yes, it is.
And you mentioned to the jury that there are fragments and such. When you receive fragments and projectiles or bullets, I guess, what do you normally do with those types of objects?
With bullets and bullet fragments?
Yes.
So we will look at our evidence, we will examine it and essentially make our comparisons. So the first thing that we're going to look at are those class characteristics. So we're going to ensure that all those projectiles are exhibiting the same class characteristics. And then we're going to use our microscope to look at those individual characteristics and start comparing those and rendering our conclusions that way.
Okay. Did you also, you stated earlier that you received 10 40 caliber shell casings and 14 9mm shell casings or cartridges. Do you recognize State's Exhibit 7? And you're more than welcome to open it.
Yes, I recognize it.
Okay. All right. And what did you ultimately do with these 10 40 caliber and 14 9mm shell casings?
So essentially, we performed the same comparisons. Again, when I received all these cartridge cases, I separated them by class, 40 caliber versus 9mm cartridge cases. And then I intercompared those 9mm cartridge cases to each other and those 40 caliber cartridge cases to each other to render my conclusions.
We can go to page 2, please. This next page where it says results and conclusions is this is where you document your results and conclusions from your tests.
That is correct.
All right, starting with this first paragraph. Do you mind just reading this and then telling the jury what this means?
The first
first-
result, okay.
Yes.
It says microscopic examination and comparison of the bullets and bullet jacket, items 2A, 3A, and 3B, reveal that they were fired from the same firearm based on agreement of class and individual characteristics and are consistent with being fired from Remington, Ruger, Springfield, and Taurus 9mm pistols. This list is the list that is provided is only provided as an investigative lead and is not intended to be an all-inclusive list.
And so what are 2A, 3A, and 3B? Where did you get those particular?
So those were from the Fulton County Medical Examiner's Office. Those were projectiles, 2 projectiles, and I believe a projectile jacket, bullet jacket, yes.
Now, at some point in this particular paragraph, you said that it's not an all-inclusive list and you can't definitively say that it came from any of those particular types of firearms or pistols.
So the list that we provide for our what we call a determined type weapon are the most common manufacturers that we see on a day-to-day basis. There are other manufacturers that are included in that list, but all of these manufacturers exhibit the class characteristics of the projectiles.
And if we could go down to, just make sure. Yeah, can we go scroll down just a little bit, please? All right. And if you don't mind, can we talk about that second paragraph, please?
Yes, I'll just read it. Microscopic examination and comparison reveal that the bullets and bullet jacket, items 2A, 3A, and 3B, could not be identified or eliminated as having been fired from the same firearm as the bullet fragments, item 2B, due to a combination of damage and lack of sufficient class and individual characteristics.
Okay, what does that mean?
So that means that item 2B was too damaged to make any determinations about.
Okay, and that 2B also came from the Fulton County Medical Examiner's Office?
Yes.
All right. Did you make these sort of conclusions with all of the items from from the Fulton County Medical Examiner's Office and report them in your findings here?
Yes, I made them using the other projectiles from the medical examiner's office.
Okay. All right. If we could go down to, I believe, I just want to. Right here. Okay.
Okay.
This paragraph.
Yes. Microscopic examination and comparison of the cartridge cases, items 5, 15, 17, 20, 22, 23, and 32 through 35 reveal that they were fired in the same firearm based on agreement and of class and individual characteristics, and are consistent with being fired in Glock and Smith & Wesson 40 caliber pistols. This list is provided only as an investigative lead and is not intended to be an all-inclusive list.
Now, let me ask you a question. If you received a firearm from, I think it was Union City Police Department, would you be able to compare these items 5, 15, 17, 20, 22, 23, 32, and 35 with that particular firearm?
If the firearm exhibited the same class characteristics, then I would test fire that firearm and compare those components to the evidence I received.
Did you receive any firearms in this matter?
I did not.
Okay, we can go down to the second, the one underneath that paragraph.
Microscopic examination and comparison of the cartridge cases, items 6, 8, 9, 13, 14, 16, 18, 21, 24, 25, 26, 30, 31, and 36 revealed that they were fired in the same firearm based on agreement of class and individual characteristics. However, they did not reveal any unique characteristics that could be used to develop a list of possible firearms in which they were fired.
So the other, these particular items, 6, 8, 9, 13, 14, 16, 18, 21, 24, 25, 26, 30, 31, and 36, you weren't able to find a class of guns or pistol or firearm that came.
So they have class characteristics, but unfortunately the class characteristics are just too common to be able to narrow down a list of firearms.
Let me make sure. All right, hold on one second, please. All right, I have no further questions for this witness.
Any cross-examination?
Good morning.
Good morning.
How are you?
Good. How are you?
Doing well. I'm going to show you a piece of State's Exhibit 3. Might not be the best stop, but have I talked to you about, did I talk to you about something this morning?
Yes, you did.
You some questions?
You did.
Did I show you a gun?
You showed me a picture of a gun.
Okay. Good one. And the picture I showed you was it kind of like a blown up portion of right here? Kind of to the upper left-hand side of the screen?
It was consistent with that, yes.
Okay, and can you just tell me what time is on the screen?
23:02:11.
Okay, and can you tell the jury what is on the back of that gun?
So just based on a picture, it is consistent with being what's called a switch, which typically a Glock switch is, it replaces the back slide plate of a Glock. It slides on, and if it's working properly, tends to render a Glock full auto, which means one trigger pull with multiple rounds being fired.
Is a switch legal?
It is not.
Can you buy a switch in the store?
No.
Is it for military grade?
No, the military does not use a Glock switch.
Okay, where do you get a Glock switch?
I do not know.
Okay, why, do you know why they're illegal?
Because they render a pistol full auto.
Okay, so that means instead of being like 1, 2, 3 trigger pulls, one trigger pull can push multiple bullets at one time?
Yes, so semi-automatic is one projectile fired per trigger pull. Full auto is one trigger pull will render multiple projectiles being fired.
Okay, and as an expert, are these dangerous?
Any gun is dangerous.
I mean, if you can't buy them in the store, have you ever seen one?
Yes, we see them all the time.
Okay, and when you see them involved in the cases that you get sent to GBI?
There have been switches on the cases sent to the GBI, yes.
Now, to have that switch on that gun, it had to have been altered?
Yes.
Thank you.
Can you redirect?
Yes. Were you able to examine that particular firearm?
No, I was not. That is solely based off a picture.
So do you know if that switch, if it was a switch, was working at the time?
I do not.
No further questions. Thank you.
Can you recross on that point only?
No, you're fine.
All right, can this witness be excused?
Yes, Your Honor.
All right, thank you, ma'am. State may call us next witness.
Your Honor, may I have a second, please? State rests.
All right, members of the jury, there's something we need to take up outside of your presence for a little bit, so I'll ask you to step to the back and we'll be with you shortly.
After the jury.
They don't have to see.
All right, thank you, everybody. Any motions on behalf of the defense?
Yes, Your Honor. Okay, so one, defense moves for a directed verdict. I don't, in my notes from yesterday, I don't have it that venue was proven. That's my first. Do you want me to go through?
Yeah, I
my
would just go ahead and
arguments?
outline it all, and I'll let Ms. Russell respond.
Okay, defense moves for directed verdict on count 3. Count 3 charges my client with armed robbery for on the 20th day of April 2019, did unlawfully with the intent to commit theft, take a handgun, the property of Alejandro Brown, from the person and immediate presence of Alejandro Brown by use of a handgun and offensive weapon. I would argue that the evidence in this case, via State's Exhibit 3, the video indicates that Alejandro Brown was actually outside of the store at the time that the firearm was taken, so that an armed robbery was not committed in the form of having taken an item from presence or immediate presence, 1, and 2, that use of a handgun to take the gun wasn't proven either through State's Exhibit 3. So 1, that it wasn't on him or in his area, and 2, that
Because the gun was still inside the store,
right, and he was outside.
about, what would you say, that 3 to 4 feet away?
Understood, with the door closed,
Okay.
but not on him or immediate presence. So similarly, if the gun was outside of a vehicle, or if the gun, so those are my main 2 arguments. Venue and moving for directed verdict on property.
All right. Anything else?
No, Your Honor.
Okay. All right. Ms. Russell.
Yes, Your Honor, I believe through Detective Baker, there was a map that was introduced. I asked her, is this in Fulton County? She did admit that that map was, or excuse me, the Chevron store where this incident took place was in Fulton County. I believe I then asked again, Miss Lieutenant Nelson on yesterday about venue. I asked her that located in Fulton County. She did agree that was also in Fulton County. So those 2 witnesses did prove venue by preponderance at this point, Your Honor. Your Honor, as far as the armed robbery is concerned, I have multiple cases. Welch v. State, 235 Georgia, 243. It's a 1975 case. Battle versus State, 155 Georgia App 541. It's a 1980 case. Waters v. State, 161 Georgia App 555, which pretty much, Your Honor, immediate presence in the context of armed robbery stretches fairly far. And if what was taken was under the victim's control or the victim's responsibility, and that's what I'm going off of, Your Honor, victim's responsibility, and the victim was not too far distant, Your Honor, than armed robbery, including the immediate presence. We have proven that. As far as the victim being down, as far as the victim being down and him taking the firearm afterwards, excuse me, I think I also have cases for that. And specifically, I think these cases were the intent to commit a robbery. Vergara versus State, 287 Georgia, 194, 2010. Kirk versus State, 271 Georgia App 640, it's a 2005 case. Hudson versus State, 234 Georgia App 895, it's a 1998 case, where in those particular cases, they were, the jury was able to, or I should say, they were able to, I guess the courts ruled, Your Honor, that a theft was completed after force was employed against a person. And a conviction for armed robbery is authorized regardless of when the intent to take the person's property arose, whether the victim was incapacitated, and even if the victim was killed instantly. So I think those 2 cases, or excuse me, those multiple cases, Your Honor, I cited, get us past this point, and that this should go for a jury, to a jury.
All right. If it's, as it's your motion and your burden of proof, Ms. Fagan, I'll let you have the last word if you have anything else you want to add.
No, Your Honor, not this time. I would like a confirmation if the court reporter can give us if Fulton County was actually testified to.
I don't know if that's something we can do, but we can try. And generally, and I'll just say my inclination in cases where venue is, if it's just there's a total failure to prove it, it wouldn't be to grant a directive verdict, but to reopen the evidence. So we can find the time to do that if we want to double check that. For now though, based on the state's representation here, as it relates to venue, I don't think the defendant would have met his burden construing all the inferences against the movement. As for the armed robbery count, raising the issues of what exactly it means to constitute the immediate presence and the use of force, being generally familiar with with the line of cases that the taking can occur before, after, or during the use of force. I think that the evidence as presented would suffice to get the issue to a jury on count 3 as well. So the motion is preserved for the record, but it is denied. Based on what was informed of this morning, I think it sounds like this would be the appropriate time for me to go through and have a little back and forth with Mr. Young. So I'll do that now. Mr. Young, just have a few questions for you, all right? You understand that you have a right to testify, and if you want to testify, then no one can prevent you from doing so. And do you understand that no one can make or compel you to testify? That is, do you understand you have a right not to testify if you do not want to? And do you understand that not your lawyer, but you personally are the one who decides whether you will testify or not? Do you understand that if you do not testify, then the court will instruct the jury that your decision cannot be used against you? Do you understand if you choose to testify, you'll be examined by your counsel and cross-examined by the state? Do you feel you need any additional time to think about whether you want to testify?
May I please talk with my lawyer, Your Honor?
How much time do you need?
5 minutes.
Okay, that's fine. We're going to hold in place, Ms. Fagan, or do you need to step into the side room? All right. All right, we could be back in just a few minutes here. We'll hold in place.
I need you to print 2 things, especially because. Stop. No, I said, you know.
Hmm.
All right, defense counsel and Mr. Young have returned. So Mr. Young, I'll just repeat the last question, which is, do you feel you need any additional time to think about whether you want to testify?
No, sir.
All right. And do you personally want to testify or not? All right. So I find the defendant has decided to testify with a complete understanding of his rights. So with that, I believe we are ready to bring back the jury. Anything else we need to take up?
You like him to take the stand now?
If that's the intention is to have him first up, then yes, let's go ahead and do that. And Deputy Scott, when you're ready, if you could bring in back the jury.
You know Van Home can shoot the things in the air. She plays that disc game. They gotta go find out.
You're ready, Your Honor.
Thank you, Deputy Scott. All right, members of the jury, right before we broke, the state rested its case in chief. And at this point in the trial now, we transition over for where the defense can present evidence. They have no burden of proof, so the defendant doesn't have to present any evidence whatsoever, but they can choose to do so. Ms. Fagan, you may call your witness, if any.
Your Honor, defense calls Airieon Dominique Young.
Raise your right hand. You swear or affirm that the testimony should be. Please state and spell your last name for the court.
Yes, sir. Good morning, everyone. My name is Airieon Young, Airieon, last name Young, Young.
All right. All right. Are you nervous?
Yes, ma'am.
Do you understand that you have the right not to testify?
Yes, ma'am.
Are you waiving that right?
Yes, ma'am.
Why?
Because I want to tell my side of the story.
Okay. Let's start with something else. Okay. Do you have a nickname?
Yes, ma'am. Since I was younger, well, my name is Airieon Dominique Young. My family has been calling me Domo for short. That's short for Dominique.
Okay. And all right. Let's go straight to April 20th, 2019, okay?
Yes, ma'am.
On April 20th, 2019, did you go to the gas station?
Yes, ma'am. But honestly, I didn't even plan on going to the gas station. We drove past the gas station and we turned around because we wanted to get drinks, but I didn't even want to go to the gas station, ma'am.
When you were in the gas station, after you got your drinks, did you see Alejandro Brown?
Yes, ma'am.
Did you know him?
I knew him as Dro. Maybe a summer before this, me and him had dealt with the same girl named Diamond, and on multiple occasions he FaceTime me on like Instagram and stuff, and like make threats to me and tell me that when he saw me, he was gonna fucking kill me. I don't know if I can say stuff like that, but he threatened me on numerous occasions and told me that when he saw me, he was gonna kill me.
All right, did you pass your drink?
Yes, ma'am.
Why?
Honestly, as soon as I saw him, I was in fear for my life. I was preparing myself because I honestly didn't know what was about to happen. I just didn't know what was about to happen.
Okay. When you saw him, were you mad?
No, ma'am.
When you saw him, why didn't you pull your gun out?
I didn't feel it was a reason to. I mean, we're in a convenience store. Why would I pull a gun out on somebody?
Did you keep tapping your pocket?
Yes, ma'am, because I definitely knew from the threats that he made to me that I needed to be prepared, but I honestly didn't think it was going to go to that furthest extent.
All right. After the shooting, did you take the gun off the floor?
Yes, ma'am,
Why?
because I just was shot, and I didn't want me or any of my friends to be shot. I didn't want to be shot again. I didn't want any of my friends to be shot.
Okay. Did you know he was dead?
No, ma'am.
Or, well, I don't think he was dead yet. So did you even know?
No, I didn't even. I was sorry. I didn't even know where he was at when I came back from the back. All I knew was I was shot. I was panicking, and when I saw the gun, my first instinct was pick it up. This just caused me bodily harm. My first instinct was to pick it up.
All right. When you left the gas station, where did you go?
I went straight to Grady Hospital.
All right. Were you shot?
Yes, ma'am. I was shot. I had 2 holes in my stomach, one in my arm, and one in my back.
And what, do you remember the car ride to the hospital?
Honestly, the car ride was like a blur. I know I passed out, and then when I got to the hospital, my friends were like, come on, Dominique, like, get up, gotta get up, yeah, gotta get up. So, I mean, that was my experience to the hospital.
All right. Had you ever been arrested before?
No, ma'am.
Were you allowed to buy firearms?
Yes, ma'am.
Did you buy the firearms in a store?
Yes, ma'am.
All right, let's talk about the hospital. Now, did you give them the name Hassan Mohammed?
Yes, ma'am, I did.
Why?
I was scared. I didn't know at the time. I didn't know he was dead. I didn't know if somebody was gonna come back to the hospital. I didn't know if he was gonna come to the hospital. I didn't want him to see my name or try to do something to me. I know that might sound movie, but in my head, that really, I'd never been through anything like that. So in my head, I didn't know how that was gonna play out for me. I really didn't. I was just scared.
Did you pull Hassan Mohammed? Did you pull that name out of a hat?
No, ma'am.
Okay, where'd that name come from?
I'm Muslim, and that's honestly my name. Like I'm not sure if anybody's familiar, but when you join Islam, they give you a attribute that you go by. So honestly, I don't even go by Damo or any of that. Like people who know me in the community call me Hassan.
Okay, and when did that start?
I took my Shahada of 2018 September.
How old were you?
2018. I think 21, about to turn 22, man.
The address, Yellow Rose. Did you pull that out of a hat?
No, ma'am.
Where do you get Yellow Rose from?
And I don't even say it, but this is my grandma address. My grandma address is 4428 Pink Rose Court, and it's connected to Yellow Rose Court. But the way the streets are, if I literally pull them up on the maps, you could get confused. But I'm not trying to make any excuses. I just honestly, I was scared. I was scared. I'm not gonna lie.
What about the phone number? Did you change a digit?
Yes, ma'am.
On April 20th, 2019, did you have the intention or the motive to kill Alejandro Brown?
No, ma'am. No, ma'am.
Did you have the intention or the motive to rob
No,
Alejandro?
ma'am. No, ma'am.
All right. So you're emotional. We're all emotional. Why are you emotional?
Because this experience has been one of the most traumatic things I've ever been through in my life. I don't know if any of you guys could tell, but on the video, I originally weighed way more than I do now. Since this happened, I can't eat, I don't sleep. I literally have to talk to therapists just so like I'm able to be comfortable to be around people. I don't think anybody understand what it feels like to be 27 and be scared to go have a phobia of going to gas stations. Like, that's not even like realistic thinking, but that's 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 my day-to-day living, and I don't think anybody understands how that feels.
Now, you just said you didn't want to give your grandma's address. Is there a reason why?
Yes, because my grandma, we have received multiple threats from the,
Yeah, when a council wants you to approach, unless you're going to rephrase or move on. Well, I don't think, let's hear this first.
Right now.
yes, ma'am.
Nothing further.
Thank you.
All right, good morning, Mr. Young.
Good morning.
All right. Okay. You were shot by Mr. Brown, right?
Yes, ma'am.
And you went to the hospital.
Yes, ma'am.
All right. And you at some point, you went to the hospital, you received some treatment,
Yes, ma'am.
right? But you left early.
Yes, ma'am.
Why'd you leave the hospital early?
Honestly, ma'am, I just was scared. I'm not trying to make any excuses for anything.
You were scared of what?
That the now victim would come up there and do something to me.
And when you exited the gas station, you looked out of the store before calling your friends, right?
Yes, ma'am.
And when you looked out the store, you saw Alejandro Brown down on the ground, correct?
Yes, ma'am.
Right, you looked at him, right?
Yes, ma'am.
Right, and his pants were below his waist.
Yes, ma'am.
Right, his pants are actually down to his sides, correct?
Yes, ma'am.
There was blood coming out of him, correct?
You could say that, yes, ma'am.
And you had already taken his firearm, right?
Yes, ma'am.
Right. So he was down on the ground. You knew he had been shot. You had taken his firearm already. You were at Grady, correct?
Yes, ma'am.
And you were still scared of Alejandro Brown.
Yes, ma'am.
Okay. All right. You said on direct that you had never been in a situation like this before. Is that correct?
Yes, ma'am.
All right. And at this point, you're claiming that this was self-defense, right?
Yes, ma'am.
All right. And you have never been in a situation like this before. That's your testimony today.
Yes, ma'am. I've never been in a incident like this. Involved. No, ma'am.
Okay. So I want to take you back. Yep, let's approach. You already have it printed, Nicole.
Yeah, one second.
May we have a moment outside the presence of the jury?
I think these are just different reports to the same textbook. The one. It's different reports to the same textbook.
That's mine, that's yours.
No, this one I just put up there.
I just,
Do this.
Okay.
Summarize the first. I think as proffered by Ms. Fagan, the defendant was about to detail that he had received threats after the first trial that occurred in 2022. And essentially I indicated that I don't think that those would be relevant under 401, and I certainly don't think they would pass muster under the 403 balancing test. So instead, Ms. Fagan pivoted and just got into this general state of feeling now is that he was scared. Anything else I need to add to that, Ms. Fagan? Okay. And then here we are on this next issue on the second bench conference, which is that the state potentially has a incident from 2018 they feel is relevant here. So anything to add to that from either party at this point?
not at this point,
2015?
not at this point. There's 2017. There was a 2018 case, excuse me.
Okay.
But I just gotta make sure that I have it. Fine.
Right, so the objection is that there's
But-
no.
Can we just
Let it
wait one
confirm
second?
first.
Yeah.
Got it. Let me see if I can get it for you. But not the 15. You're only talking about you want.
All right. Let's go off the record while y'all can keep talking back and forth. And so let me know when you're ready to resume. And then while we're waiting, can you look through the directives?
And
You would say.
Your Honor, am I able to go talk to my lawyer? Am I able to go talk to my lawyer this time? Oh,
what you say?
Okay.
See. No, he did. Oh, right. I'll find it.
That was it, right? Yeah. That's it. Wait, let me. All right, you good?
I don't have.
Oh, wait, hold up. All right, we can go back. You ready? We'll go back on the record. Well. Let me see that.
I know, just it's weird. It's with Detective Moss.
Okay.
This is a jail call when he says it. And he shot that. So he's on the phone, jail call. Saying he shot him.
Okay. Yeah.
Okay.
Yeah. Just let me know when you're ready. Good. All right, let's go back on the record. If we can, just to kind of, I want to discuss where we are and kind of where I see the lay of the land under the rules of evidence. So based on the testimony of Mr. Young and what's been alluded to, I think, in opening as well, I think the character door is open under 402, which means that the defendant has opted to place his character of being a law-abiding citizen at issue in this trial. And that he did that by, and counsel did that by saying that he's, quote, never been in trouble before, never been arrested. And so if the state had specific instances to rebut that exact trait, then those would be admissible and relevant. So that's point one. Point two, the exact quote was that he had never been through anything like that before. And so if there's something that is impeachable on that point, then that also could come in. So those are the only two avenues I see. And so with that, are we at a point here to discuss what the state has
Well,
and is trying to tender?
can I just say that I think on the first point, I don't have anything where he has been arrested, convicted. I don't have that. However, on the second point, Your Honor, I do have something where in the past, in 2017, it was, there was a shooting at a home and Mr. Young and Mr. Jabari Johnson both shot back and that particular person was killed. Now, it wasn't self-defense. They did shoot in self-defense. However, he stated that he had never been through something like that before when clearly he was shooting back in self-defense. So that's my,
When you say he shooting back, so a gun was in Mr. Young's hand?
well, he did not say that to the officers, but then I believe later on he admitted it to.
That's what we were.
We're trying
figuring
to,
out.
we're trying to figure out who he admitted it to, but I think he could, I mean, I think I should be able to explore that with him.
Okay.
That he had never been in a situation like that before.
All right. Any initial reactions? I know we're still clearing up that one point, Ms. Fagan, but any initial reactions to that?
Well, I think my opinion is determinant on clearing this up.
Okay. All right, I'll give you a little bit more. I don't think we can spend all morning on this, but we'll see if you can get some
And-
guidance.
And just so that I'm clear, clearing what that he actually, because I think I should, as I have a thorough sifting cross, I think I can ask him the question about him being in a situation like this before. It was a self-defense incident. He was
Well,
looked
what I'm
at
not
as a
clear so
suspect.
far yet is whether it was him exercising self-defense, right? Was he just happened to be there while someone else exercised self-defense, or was he involved in it in some, higher degree? That's what I'm trying to see. Because if he was just there watching someone else exercise self-defense, I don't think that's going to be impeaching of that statement.
Okay.
If he's involved in some way, maybe through a party theory, then sure.
This will be, let's see.
Oh, let me see. Just this text at the bottom?
So-
Well, I'll remember. I'll ask him. The redacted version.
Oh,
Yeah.
Or go, try my. Yeah, try. And I can let you see, my computer too. Alright. Your Honor, we're gonna keep looking for it. I'll move on from this point, but I'll stand up. It's my belief that, Mr. Young did fire back. But as soon as we find it, then I'll.
And your belief is based on just, you've got some reports or some files in front of you
Yeah,
that indicate that?
yes.
Okay.
I have notes that have been written, where it says that. So I'm just trying to go back and find the exact report. My own notes is what I'm saying. So,
Because
Ms.
I
Washington.
so I'm disputing that I've seen anything that actually indicates besides a one line that he actually opened fire. So that's what we were doing. But,
Listen, like you have like a whole recorded interview?
well, they were looking, the report indicates a jail call, but he wasn't in jail. So that's why we were listening to see if we could compare voices,
and it wasn't him.
and it wasn't him.
So we're trying to see.
So now yeah.
and couldn't have been him because he wasn't in
He wasn't in
jail.
jail.
Well, look, I mean, if it's a situation where there's no even contention by the state that whatever happened was unlawful or not in self-defense, it's really not touching on character. It's mainly purely for impeachment. So if that's the case, then it's either a good or a bad impeachment. He can explain it if he wants to, and that the state's pretty much stuck with that. And I don't see it as being kind of that poison pill that we're usually trying to shield the jury from before we work all this out. So I'm inclined to say if the state wants to, kind of put that on the back burner, save it to the end, they can. But I'm also thinking that based just on what they have so far, they've had this, they've reviewed it, they have a reason to believe he had some more involvement in it. They can confront him with it, and we'll see where it goes.
Right, and I think that's why the state was willing to take a break because it's questionable. And questionable because he's never admitted that he's shot.
Right. In which case, we would go from there. So I think we would bring in the jury, we'll resume the cross, and we'll take it as it comes. I think that the state can go ahead and bring it up, and then depending on his answer, we'll see what the next phase is. What else was I going to do? Oh, and then while we're here, I want to ask again about State's Exhibit 8. There had been talk yesterday, I guess. I didn't know what the text was at the bottom, but now I see that it's just this liked indication. That was still a hearsay objection that we need redacted. Is
That
that,
was the one that we're all
That's the
okay
one
with,
we're good with.
was there one that we were not?
already handled.
I just already handled it.
It's already been submitted as a redacted version?
That's the redacted.
This is the redacted version. I understand. Okay. Then State's Exhibit 8 is good to go. We can bring back the jury.
She'll call on. Bring her, see if you can call mom, and then we'll bring her in. Rebuttal.
Thank you. State may resume its questioning.
Okay, Mr. Young, so I asked you, on direct, you said you had never been through anything like that before. Is that right?
Yes, ma'am.
All right, and is that still your answer today?
No, ma'am.
Okay, so explain, you have been through something like this before.
Yes, ma'am.
Okay. Was this in 2017?
Yes, ma'am.
All right, so in 2017, at some point, you had to use a firearm in self-defense then.
Yes, ma'am.
All right. And you were cleared of those charges.
Yes, ma'am.
All right. And it was in self-defense, right?
Yes, ma'am.
Right. And you were with Jabari Johnson.
Yes, ma'am.
All right. Jabari Johnson is the same person that you were with in this particular incident, right?
Yes, ma'am.
Okay. And Jabari Johnson got shot.
No, ma'am.
He didn't get shot?
No, ma'am.
Okay. Nobody else got shot?
No, ma'am.
Okay. All right. However, there was another person who you were defending yourself from that did get shot,
Yes, ma'am.
and he died.
Not person I got into it with, no, ma'am.
Okay. But there was somebody that passed away in 2017.
Yes, ma'am.
Okay. And you stayed on the scene.
Yes, ma'am.
All right. You gave your name
Yes, ma'am.
You gave Airieon Dominique Young.
Yes, ma'am.
You gave your correct and full telephone number, correct?
Yes, ma'am.
Okay, all right. But in this case, you decided not to do that because you were scared of a person on the floor.
Yes, ma'am.
Okay. All right. Now, when you went to the hospital in 2019, excuse me, April of 2019, you told the staff you were at a convenience store, heard shots, and then ran, right?
Yes, ma'am.
You did not tell them that you feared for your life and somebody else was shooting at you.
No, ma'am.
Okay. You did not tell them that you were shooting.
No, ma'am.
Okay. This was a safe place, correct?
The hospital,
Yes.
depending on how you look at it.
Okay. Did anybody else come to the hospital to get you or find you?
To get me or find me?
Yeah, you said you were scared of somebody maybe finding you.
No, ma'am, they did not.
Okay. All right. I want to go back to there was no other people in the store besides you, Penny, and Jabari, the victim, and the two cashiers, correct?
Yes, ma'am.
Okay. What's Penny's last name?
I'm not sure.
Okay. How did you meet Penny?
Through doing music?
Doing music?
Yes, ma'am.
Okay. What type of music?
I know how to engineer and like do like mixed and mastering. Like if you have a song, I would be the person who has to listen to it a million times and make it sound good.
Okay. And Jabari, how did you meet Jabari?
Same way through doing music and well, from going to school together and music.
Okay. You and Jabari don't hang together anymore?
No, ma'am,
All
I
right.
can't.
All right. Now, after you left and you got into the vehicle, did you, you said you kind of passed out,
Yes, ma'am.
all right. But you were able to call your girlfriend at the time?
I didn't call her, but Jabari called her from my phone. Yes, ma'am.
Okay, so Jabari called her from, what kind of phone did you have at the time?
iPhone.
All right, you had an iPhone and you had to put in your code?
He already knew my code. We were friends.
Okay, Jabari knew your code and he knew who your girlfriend was?
Yes, ma'am.
And they didn't make any other stops before taking you to the hospital?
It took me straight to the hospital.
Okay. And they didn't stay at the hospital with you?
No, ma'am, they dropped me off in the front.
You just got dropped off at the front and they didn't walk in with you?
No, I knew the mother of my child was meeting me up there.
Okay. All right. So you had woken up at that point in time?
Yes, ma'am, that's when they woke me up when I got to the hospital.
You put the victim's gun in your pocket, right?
Yes, ma'am.
Okay. And you knew it was his firearm, right?
Correct.
And at some point he had it in his possession, right?
Correct.
Okay. And you kept it.
Are you talking about at the time?
Mhm.
Yes, ma'am.
You left with it.
Yes, ma'am.
You did not return it to Mr. Brown.
Of course not. He just shot me with it.
Okay. And you did not try to return it to Mr. Brown?
Of course not.
Okay. Where is the gun now?
Well, like I said, when I was in the car, I definitely passed out and I didn't walk in the hospital with him. So I honestly can't tell you.
So both guns that you had, Mr. Brown's and your gun, you don't know what happened to those guns?
They were in the car. My last time seeing them, I know they were in the car.
You never asked Jabari what he did with the guns?
No, ma'am.
You didn't ask Penny what he did with the guns?
No, ma'am.
You didn't think that that would be helpful?
By the time everything was happening, I already turned myself in. I didn't have a chance to.
Okay, so you turned yourself in, but when you turned yourself in, you were under arrest, right?
Right.
Okay, and you didn't think that having the guns would be helpful?
No, ma'am. My first lawyer didn't suggest that, so I didn't, I didn't know.
And you never asked them what they did with them?
No, to this day, it's from me coming home, I haven't talked to either one of them since I've been home. So no, ma'am, I haven't.
Okay, and so, all right. Let's see, back to this question. Now, when you walk into the convenience store, you go to the back of the convenience store, right?
Correct.
Okay. And when you go to the back of the convenience store and you're back in the back, you're talking to Jabari, right?
Yes, ma'am.
Talking to Penny.
Yes, ma'am.
All right. And you are picking out drinks in the back of the convenience store.
Correct.
Right. At any time in the back of the convenience store, do you feel around for your gun?
Mm-hmm. No, ma'am.
Are you tapping your pockets for your gun?
No, ma'am.
Okay. So when you grab your drink, you walk to the front of the convenience store, right?
Yes, ma'am.
All right. And you see Mr. Brown. Is that right?
Correct.
When you see Mr. Brown, you immediately pass your drink off.
Yes, ma'am.
All right. And when you pass your drink off, is that when you said you feared for your life?
Yes, ma'am.
Okay. And at that point, Mr. Brown had not seen you, right?
He did. He saw me through the reflection.
No. When Mr. Brown first walked in and you first saw Mr. Brown, he had not seen you.
Oh, correct.
Okay. So at that point in time, you feared for your life.
Yes, ma'am.
Even though Mr. Brown had not seen you.
Correct.
Okay. And you feared for your life because you say that he threatened you on Instagram.
Yes, ma'am.
Okay. Do you have those Instagram?
No, ma'am. That was so long ago. I don't even have those Instagram anymore.
You don't have that Instagram
No,
anymore.
ma'am.
And you didn't. So how long ago from 2019 did he make those threats to you?
The following summer. Well, the summer.
Prior summer.
Prior summer. Yeah, excuse me.
So prior summer.
Yes, ma'am.
So in 2019, on April 20th, 2019, you would have had those messages.
No, ma'am. I still didn't have that page.
You still didn't have them?
No, ma'am.
Okay. And there was no.
Well, excuse me. It wasn't messages. It was an Instagram call. Like I literally seen. I see FaceTime. It was an Instagram call.
Okay, it was like a FaceTime.
Yes, ma'am.
All right. So on FaceTime, when someone makes a call, it does it show up like a message?
No, ma'am. It shows up like somebody's calling me from Instagram. I didn't even know who it was. I just answered the phone.
Okay. And when you answer the phone, you see Alejandro Brown.
Right.
Okay. Through a Instagram phone call.
Correct.
Okay. And he tells you that he's going to F you up.
Oh,
So many words.
no, he told me he was going to fucking kill me.
Okay.
Verbatim.
I'm sorry?
Verbatim.
Okay. That he was going to fucking kill you over Instagram.
No, ma'am. It was over a girl.
No, it was over the Instagram.
Oh, yes,
phone.
ma'am. I apologize. Yes, ma'am.
But it was over a girl.
Right.
Okay. And Diamond is her name?
Yes, ma'am.
What's Diamond's last name?
I'm not sure. I didn't get that too deep into it with her. I'm not really with the crazy, having guys be crazy and stuff and try to take it out on me. It's not my forte, man.
How long had you spoken or had talked or dated Diamond?
Maybe like a month. I wouldn't even say that long, maybe 3 weeks.
So you were dating Diamond for 3 weeks and
Nope, we weren't dating, ma'am. I was just somebody I was just dealing with.
Okay, so what do you mean by dealing with? You were talking on the phone?
Yeah, I talk on the phone with her. I might have seen her a few times, but we weren't like dating. Like it wasn't like she was my girlfriend.
Okay, so you were maybe talking on the phone and you would see her a few times.
Yes, ma'am.
And during that 3 weeks, Mr. Brown found out about you.
Yes, ma'am.
And he said that he was gonna fucking kill you.
Yes, ma'am.
And you said that happened how many times that he said he was gonna fucking kill you?
Numerous. He did it numerous times.
Numerous times.
Yes, ma'am.
Over a 3-week fling you had with somebody.
Right.
Okay. And so, and you had never seen Mr. Brown in person. Is that right?
I mean, passed through him before, like we've passed by each other before, like me dealing with the girl, but like, at the time I didn't know him.
Okay, but you didn't know him.
No, ma'am.
Right. And so at some point when you, and that happened the prior summer, so that happened in 2018, right?
Correct.
All right, a whole summer goes, or a whole year goes by. Not a whole year, maybe 8 months goes by. Is that right?
Give or take.
Okay, give or take, maybe 8 months go by. And at some point in time, you see Mr. Brown. Is that right? In the gas station.
Yes, ma'am.
Okay. And you remember that phone call over Instagram Live that he said he was gonna fucking kill you.
Yes, ma'am.
And that got you very nervous and scared.
Yes, my adrenaline. As soon as I saw him, my adrenaline instantly was like my heart start beating fast.
All right. And so at some point, Mr. Brown goes to the cashier, right?
Yes, ma'am.
All right. And you saw in the video, he has money in his hand.
Yes, ma'am.
All right. You are still in the back of him, right?
Yes, ma'am.
When you pass off your drink, you pass it to, is that Penny you pass it to?
No, ma'am. I passed it to Jabbar, if I'm not mistaken.
Okay.
No, maybe I did pass it to Penny. I'm not
To
sure.
one of them.
Yeah, yes, ma'am. Just one of them, ma'am.
All right. And then at some point, you turn your back to Mr. Brown, right?
Right, because honestly, at first I was trying to like kind of hide.
You were trying to hide?
Yeah, like I turned my back, like, but I knew like he was gonna see me already. Like I knew he was gonna see me.
Why did you think he was gonna see you if he was still facing forward and he hadn't seen you at that point?
I'm not sure if you're familiar with the glasses that. Well, I mean, I know you are, but you can see everything behind you from the reflection in the glass.
So you did turn your back at some point,
Right.
all right? And what was it, for a second, 2 seconds?
Maybe.
Okay. And then you turn back around, is that right?
Right.
You had it on you felt for that gun again.
Yes, ma'am.
You made sure you had your gun, right?
Correct.
Okay. And your gun, what type of gun was it?
A Taurus G2.
A Taurus.
Yes, ma'am.
9mm cartridges.
Yes, ma'am.
Okay. And at some point in time, your Taurus, it was loaded. Fully loaded?
What do you mean, like?
Like magazine, was it fully loaded?
Yes, ma'am.
Okay. And the magazine was inside the firearm, of course, right?
Yes, ma'am.
And you were able to pull out that firearm and shoot. You didn't have to put one in the chamber.
No, but my gun has a safety, so it was on safety. I just had to take it off safety.
So your gun was on safety?
Yes, ma'am.
Okay. Is that what you were doing in your pocket, trying to get it off safety?
No, ma'am.
Okay. When did you get it off safety?
When I fully put it in my hand and transferred it. It's
So-
just like a simple flick. It's easy to take it off safety, ma'am.
It was a simple flip.
Just like flick down. Yes, ma'am.
So you pull it out of your left hand and transfer it to your right hand.
Yes, ma'am.
Okay, but your left hand, you're able to flick the safety off.
Yes, ma'am. That's on the side. It's on.
It's on the left hand side.
Yes, ma'am.
So in your left hand, if your hand, right, is on the butt of the gun, okay? How are you able to flip the safety off with your left hand?
Cause I don't know if you're familiar with the gun, but on the
Oh, you
G2,
tell us,
on the
because we don't have it.
I'm not sure if anybody's familiar, but on the G2 Taurus, the safety is, say if the gun is in my hand like this, the safety is right here. So when I took it out, it was easy for me to just take my safety off.
So when you took it out, you were able to do all of that at the same time.
Yes, ma'am.
Okay. You didn't touch the gun. You didn't take the safety off with your right hand at all.
Well, when I transferred it into my hand, I was taking my safety off. That's
Okay.
what I was doing, ma'am.
Okay. All right. And at some point before you transfer or you take your gun out, fully out, you say something to Mr. Brown, right?
Correct.
At that point, you say something to Mr. Brown because you earlier said that you were trying to hide from him, right?
Right.
And what do you say to Mr. Brown?
All I was trying to tell him was, I told you I didn't want no problems.
Okay.
But
So,
but I wasn't even able to like fully get it out. Everything just happened so fast.
so at some point you say, I don't I told you I don't want no problems.
Right.
And then you pull out your gun.
Yes, because I was in the position where I had no choice, ma'am.
As you say, I don't want no problems. You weren't fully able to get it out, but you were able to pull out your gun at this near the same time.
Correct.
Okay. Did Mr. Brown say anything to you?
No, he didn't say nothing to me. He just turned around and upped his firearm on me. So as soon as he saw me, he upped his firearm on me.
As soon as he turned around, you say something to him though, right?
I don't say nothing until he's already upping his firearm towards me.
All right, let's look at it.
Do I watch it on this screen or
Either or. Is there something on that screen?
me? Or
It's just you.
the other, like, court?
Put it 2307. Oh, 2302. Oh.
इतना मेहनत कर रहे कौन करके पूरा उधर खेल हाँ तो क्या करा उसमें ओवर आना बोल रहा तुम क्या कौन दिया उसमें
मुझे वो बुढ़िया का था
I'll stop sharing. Go to. Now you can watch. I'm gonna go to 230201 for the record. And at this point, I want you to tell it's kind of lacking. Although don't play it yet. You didn't put and can you move that down so you can see yourself?
I think once you play the box one.
All right. I want you to say pause when you see yourself talking.
Yes, ma'am.
We'll do it together. How about that?
Yes, ma'am.
Go ahead.
अगला कल पहले दे नहीं बोलो नहीं बुढ़ा बैठा नंबर नहीं बैठा गाड़ी पे नंबर 3 पे बैठा ये पर शॉप तो उसके पे आउट से बुढ़िया में वसूल कर दिया तो बुढ़िया को मैंने दिया
It's off. The sound is off on it. HDMI. Unplug it. Will you unplug it?
Yes.
Mine won't work that way.
Is that what's this right here?
It doesn't work. That's okay. You can move on. But it's your contention that when you said something to him, Mr. Brown was raising his gun.
Yes, ma'am.
Okay, all right.
Need to switch it back.
You good to go? Good. All right. And so when you left the store after this incident had taken place, you didn't call the police?
No, ma'am.
No, you called your girlfriend,
I didn't call her, but
Somebody
the
called
mother
her.
of my child was called, ma'am.
but you didn't call the police?
No, ma'am.
Okay, all right. Um, and now, when you walked out, you know, the two clerks did you see the two clerks at all?
Are you referring to the store, ma'am?
The store manager and the other cashier that was there, did you see them?
Honestly, I wasn't paying them no attention, honestly.
Okay, you weren't paying attention to them. Did you, your two friends went with you, right?
When we left, yes, ma'am.
They left with you, excuse
ma'am.
me. And then Mr. Brown was on the ground.
Yes, ma'am.
All right. There was nobody else in the store that you saw.
No, ma'am.
Okay. At some point, you saw your face on the news?
Yes, ma'am.
Okay. And that's when you turned yourself in, after you saw your face on the news?
Give or take maybe a couple days after, but yes, ma'am.
Okay. All right. You said a couple days after.
Yes, ma'am.
All right. No further questions. Thank you.
Thank you.
Can you redirect?
When you, did your family ever hire you a lawyer?
Yes, ma'am. That was the purpose of me waiting to turn myself in.
So, the lawyer, you were advised to turn yourself in?
Yes, I'm not sure the term, but it's like a peaceful surrender, I guess, where they contact the jail and tell them that my client is going to peacefully surrender herself. I'm not sure the term, but that's what happened, ma'am.
And after your arrest, were you told that you're not allowed to talk to any witnesses or alleged victims? Is that why you can't talk to Jabari? Mr. Young, when you saw Mr. Brown, did you have a chance to pull your firearm?
Yes, ma'am, I did.
Did you choose not to?
Correct.
Why?
Because of something stupid. I wouldn't shoot anybody over a girl, and I'm not going to say I didn't think nobody would do it to me, but because I mean, it happens, but I wouldn't over a female is never that serious.
Thank you.
You recross on those points.
No, Your Honor.
All right, Mr. Young, you can step down.
Thank you, Your Honor.
Let's make call their next witness.
All right, defense rests.
Does the state anticipate any rebuttal evidence?
No, Your Honor.
All right, members of the jury. The evidence is now closed in this case. So I anticipate that we are going to get to closing arguments today. And we may even get to a point where you can begin your deliberations. And from there, it's in your hands, whether you deliberate for 5 minutes or 5 days. It's up to you. So what we need to do, though, before we can get to closing arguments, is have a conference with just the parties where we decide what the law is going to be that we charge you on. That takes a little bit of time, as I alluded to yesterday. So we're going to take a longer lunch break. If we could have you back here at 1 o'clock, and I'm hoping we can start by then. We may need a little bit more time. We'll see how it goes. But until 1 o'clock, we'll see you then. Please do not discuss the case with anyone, including amongst yourselves, and don't do any research about this case while on break. Does anyone have any questions before we dismiss you for lunch? Seeing none, we'll see you at 1 o'clock.
All right, jury.
All right. Is there anything we think we need to do exhibit-wise, or any other thing we need to clean up the record or address anything else before we would move into the charge conference?
Not before the charge conference, but I was just trying to see, Your Honor, if I can get that recall warrant sent to me.
Certainly. That warrant was actually given to the sheriffs, like it's active right now?
Yes.
Okay. All right. So,
Don't want her to.
no, understood. It hasn't been forwarded to me.
have-
So, but as soon as it is, we'll get turned around to you. Other than that, anything else from the state before we would move into the charge conference?
It's it. Sorry, y'all. Anybody can sit.
I'm sorry. I couldn't-
Is there anything else we need to take up before we go into the charge conference?
No, Your Honor. Do we-
Okay,
You have a compilation for?
we're working on it. We should be printing that now. Ms. Fagan, anything on your end?
No, Your Honor.
Okay. I'll just revisit for the purposes of the record on the speculation objections when witnesses were kind of talking about impressions of the video. I'll just lay on there that having looked a little closer at Rule 701 and a recent application in Anderson versus the state, 313 Georgia 178, that to the extent I overruled those objections, it appeared to me that these witnesses, based on their background and their handling of this case, were making statements rationally based on inferences formed by reviewing that video and other evidence they'd gathered in this case and other involvement about this case, and that those inferences would have been helpful to the jury on the issues present here. So, and then generally, as I think I alluded to as well, any ultimate issue objections are foreclosed explicitly by the rules. So I'll just clear that up. Anything, so we're going to wait on those. We're printing those. We'll see. I think the two big points still would address in the charge conference, but besides tailoring the language, would be if any side is requesting lesser includeds. And then assuming we break by or get that done by 12, I think do we need any more time to prepare for closings, or do you think the parties would be ready by 1 o'clock-ish to start closings?
If I can get during my lunch break, that'll be yes, Your Honor, that'll be an hour. I think I could be ready by 1.
Ms. Fagan, do you think you need any additional time to prepare? Okay, we'll see how well we can get through the charge conference on that. Since I know we'll be talking about it while the packet is being printed, is there a request from either party for voluntary based on mutual combat or sudden passion in this case? I'll start with the state.
No, Your Honor.
Ms. Fagan?
No, Your Honor.
All right. Okay, let's hold in place. Those should be out shortly.
Oh, one more pattern, right?
No, they're not.
You did.
I did.
What'd you do?
I have some at the back.
Transferred?
Actually, I got another one I can go over. I got one more. And kind of anticipating how we can best use our time. I would anticipate the jury's going to want to look at this video a good bit. And generally, if it was a silent video, I could just send it back to them. They could look at it all day and as many times as they want. This one does have audio on it. A lot of it's in a foreign language, as best as I can tell. It's the clerk. But I don't really hear anything else from that's material. So if the parties consent, I'll send it back. Otherwise, the jury's going to come out here every time they want to watch this video over and over again. So any thoughts about that?
Okay, and so I would just like to review the device that they're gonna be able to do it on. I wanna make, because clearly we all know how to alter.
Sure.
right?
So we've got a laptop.
Low and-
We've got a laptop for that, kind of designed for that, where we'd have IT remove the ability to get on Wi-Fi. So we'll go ahead and bring that out as well and let you take a look at it and see if you can hack it. And also make sure that this actual exhibit plays on it. This exhibit is a CD or a thumb drive.
Drive. I have a thumb drive too.
So
Oh, no, it's a CD. Yeah, the CD.
CD.
I can put it on a thumb drive.
can we get that? And does it require any kind of a special player?
It requires VLC.
We should have VLC on this laptop.
iPad too, just saying that's an Apple device and I don't have VLC.
Oh, really?
So,
Okay. So if we can make it happen, we're going to try. So if you could put it on a USB for us, and then we'll get the laptop out here for you to see if it plays. And if you could also use any dead time to start thinking through what other exhibits go out and which ones stay back. Okay?
Thank you, Your Honor.
All right.
But you said it was the sheriff.
she said.
Why she said that? So can we make sure we do something too? Okay, so you're gonna do it, yeah, even though it's.
Yes.
So it's exhibit 3.
It is.
Exhibit 3.
Wanna go to the evidence?
Well, I mean, what, the 12 pieces?
I know, it ain't that much.
What do you want? Yes. I accidentally hit the gun and she goes objection. You can't keep the gun. What did I do? Just tap? What's it? That's a good one. Can't, why not? That's a good one. Okay. You guys need a better credit. Your credit is no good. They can't pay us. You got it. Okay, here's A. How do you wanna do it? What do we, is there anything not going back? Just. This stuff? I mean, it doesn't. This is 9, I just said 8. 7. What's it want? Here's 10, 11. What is this? The 911? Where's the 911? Thank you.
So this is your 3 question.
Okay. Can you unplug that one? And let's just put it here. Not the finished version we give to it. Yeah, just the finished version. I'll take it.
Yeah. Okay, gotcha. Thank you.
Liz, can you take this to Boyd and see if it's on? Oh. Very good. Okay, can we call him, see if we have that laptop?
Yeah, he said it's square.
Okay, let's just, well, we'll do that in the break. We'll do that over lunch break. That should be easy to do.
I'm sorry, I couldn't hear you. Oh, I said it needs an order.
They were, but, that's okay.
No, they haven't been stuck.
Yeah, I that's the one.
No, I meant like 22.
Oh.
32. Sorry.
Yeah, I put.
I
it
was. This ends at 32. You have 33, 34.
34.
Got you. And then are you redacted this indictment? I got better love on my directed verdict on Marbury argument last time. I got love on it.
Well, apparently you got love from the jury too.
Got love on
He really love.
it. Yeah. All right, tell me what you want. There's this.
I'll redact that.
Have we already done the verdict form?
Oh, I've got that. I can print that out.
Oh, here, we have. Here, let's go through it. Well, we're just gonna go through it together.
Gonna be done.
Can I get a copy of your redacted version when you do it? Or you don't have the paper? Or you don't have enough paper?
Oh, no, I'll get you a copy. I get everybody a copy.
Yeah.
You have stickers?
Yeah, I'm using one of my precious few remaining.
How many you have left?
About 5 or 6.
Okay.
Danielle, what's your non-patterns? So I can jump.
Yeah, let's just run through them. All right, we'll go on the record here in a second. And I don't think there were any non-patterns here. All right, we're back on the record to begin the charge conference. I've provided the parties a 63-page document with all the consolidated charges, a few others of my own that I threw in there just to see if anyone was interested or whether they were applicable. And so I have a copy that I'll mark as Courts Exhibit 1. And generally, instead of formally doing one, both parties' position for one after another, I'm just going to go through them, and then you can just stop me if there's something that you flag or want to. All right, so as I mentioned, this will be Courts Exhibit 1. State's going to prepare a redacted version of the indictment. That'll be Courts Exhibit 2. And let's just go ahead and get into it. So page 1, indictment accusation. It's a pattern charge tailored to the indictment with the remaining counts. I don't see any issues there. Page 2, issue and plea of not guilty, pattern charge, no issues. Presumption of innocence. Pattern charge, we have a parenthetical, which talks about a defense being raised by the evidence, and that's what we have here with the affirmative defense of self-defense. So I would remove the parenthetical, give it in its entirety. We have page 4, a request for grave suspicion, and considering the cases there and the pattern charge on presumption of innocence that's already been given, I'm inclined not to give it as duplicative. And in this case, if you want to make a record of that, Ms. Fagan, feel free. If there's anything else you want to add.
All right, it's defense's request. I think the grave suspicion specifically will apply to intent.
All right. Well, noted for the record, preserved for the record, but again, I think it's duplicative of what we already have. So moving on, we have page 5, pattern charge on judge, jury. Then we have evidence generally, direct and circumstantial. Page 8, credibility of witnesses. All pattern charges. We get to page 9, expert witnesses. Not seeing anything to Taylor yet. Then we get to page 10, witness impeached. I think we do have some examples of that. We could say that on the defense's cross, the issues of what was on the video or what wasn't through the officers was as arguably an impeachment, as well as through Mr. Young. So I think that is going to come in here. And specifically when we get to the types of impeachment, on page 11, I think we would strike most of these, since I don't really see those as being the types of impeachment at issue here. There were no criminal convictions.
I don't think any of this.
Do we want to just strike 11 in its entirety? Any objection to the state?
I'm okay with that.
All right, so we'll just strike 11, the witness attacked. Similarly with witness supported, I think hand in hand, I don't see how that really applies here. So we'll strike page 12. Page 13. I don't think this one's applicable either. There was some reference maybe to the prior trial in the lieutenant's testimony.
Baker.
That's okay. All right. In that case, then we'll leave it in as the pattern charge on 13. Defense request for immunity or leniency, not seeing that here. So I would strike 14. Any objection, Ms. Fagan?
No objection.
All right. 15, single witness, pattern charge. I'll give it. We've got defendant's choice not to testify. And I would just strike. Well, actually, I don't know if I'd strike any of that. I think we just kind of leave it at that, right?
Right, and so in my last trial, what the court did was just strike the word not. And, well, do you send the charges back to the jury and with their titles?
No, not with the titles. Just
Okay.
scrunch them all
So
together.
if we just keep the title off, then I don't think there's an issue.
Ms. Russell, any thoughts on this one?
I have no objection.
Okay, so I would include both the parentheticals, and that'll be included along with everything else without the title. All right, page 17, limiting instructions. I don't know if I gave any. I don't think I mean, maybe an opening I did, but not for specific evidence or related to that. So there's no objection. I'd strike page 17.
No objection.
All right, hearing none. 404B didn't come in here, either for the accused or for the victim, so I would strike page 18. We do have some prior difficulties through Mr. Young's testimony. And right, so we would, I think we would strike a lack thereof. I think we can keep that in perhaps. I don't know if anyone has a strong preference.
So my understanding is that if the evidence indicates that that it was completely stranger on stranger, that's when or lack thereof is applicable. But I don't think that's what the evidence indicated in this case.
I think we keep it in. Again, I understand Mr. Young's contention that he knew or thought he knew, or Mr. Brown contacted him. But I think I should be able to argue lack thereof. There's no evidence besides what he has said.
But that is like the exact opposite of what single witness is. Like, I understand its argument. But I don't think that's.
Well, a single witness is if believed. And so Mr. Young, if believed, there are prior difficulties. And if not, then the lack thereof is something the jury could consider.
Well, my argument is that the court is the gatekeeper and there has been no evidence or lack thereof for the court to then determine that there's been evidence of that to determine what law is applicable here. And so because there's no evidence that it's stranger on stranger, it wasn't even testimony by a detective or ADA sprinkle of, well, I went through Mr. Brown's phone and I didn't find any communication ever before. So that would indicate to me or lack thereof.
But is your argument, let's say if Mr. Young had not testified, would a lack thereof be appropriate?
If Mr. Young had not testified, I wouldn't think this would be applicable,
This being,
this charge. But, because there wouldn't be any evidence.
but then there would be a lack thereof.
Oh, right, fair.
Yeah.
So fair, but I still don't think that it just, I think the purpose of the parenthetical is that it doesn't always apply. And I don't think it applies here.
Okay.
I think I would like to keep or lack thereof. Because
All
I
right.
still think I could argue that you don't have to believe his testimony.
Right.
There's a lack thereof.
I mean, I think that's where I'm falling as well, as it's an argument that can be deployed and as with single witness, it's if believed, so it could go either way, and the jury should, as the pattern sarge says, be able to make their findings and go whichever direction they want to go. So I would keep the lack thereof. I would strike a witness, parenthetical, and I would keep in the parenthetical about reasonableness of any alleged fears by the defendant. But I would strike or alleged victim in that parenthetical, because I think the reasonableness of any alleged fears of the victim, I'm not sure if there's any slight evidence to support that, though, more along the lines of Ms. Fagan's argument.
That's fine with me.
All right, so just so we're clear there, what gets struck on page 19 is a witness, the two parentheticals about witness, and then or alleged victim within the parenthetical talking about the reasonableness of any alleged fears.
And between victim and the reasonableness, are you adding an and, an or what's the flow that the court's going to read it as?
I would think an or would work there. I really have no strong preference there.
Just asking so that I quote.
Okay. All right. With that, then I would move on. On page 20, didn't hear any prior convictions, so I'd strike that one. Page 21 and 22, I'll talk about identification, because it seems that's not really contested here. Do we still need that, Ms. Fagan? All right, so I'll strike 21 and 22. We've got good character of the defendant. I think that has been invoked here, so we got to fill in the blanks and say evidence of the defendant's character, if any, has been presented to show that he has acted consistently with that character in this case. This really only came in through the defendant's testimony himself. So I don't know if actually the second paragraph of this pattern charge is appropriate or applicable. We could also further nail it down and say it's a specific character trait of, you know, being law abiding, or we could just keep it to the more general term of character. I really don't have too strong a preference there, so I'm open to any input.
I like the character trait being specific. I like the way the court mentioned it.
So how would I phrase that of law abidedness? I don't know if that's.
Evidence of the defendant's law-abiding
Lawfulness. I think it would just be lawfulness. So I'm just going to say character trait of lawfulness, if any. And then I would strike the second paragraph, because that didn't come through the opinion of another witness. It didn't come through testimony about his reputation, and it didn't come through examples of his conduct in terms of specific instances. It just really just came from his own opinion and reputation, I would imagine. All right. So not hearing anything else there, then I would strike the second paragraph and then there would just be the final concluding sentence.
No objection.
All right. Moving on, 24, definition of a crime is the pattern charge, which I'll give. Intent as the pattern charge. No presumption of criminal intent. Pattern charge. I would give the parenthetical on page 26. Presumptions and inferences, do we need this one? Is there a question of whether there was a sound mind and discretion on the part of Mr. Young?
No, Your Honor.
Okay, so I'll strike 27. Knowledge, again, generally I see that being more relevant to party of a crime or conspiracy cases, so I would be inclined to strike 27.
You said,
I'm on 28 and
Okay.
page 28 and 29, knowledge and mere presence. Again, both of those being more about conspiracy, party to a crime, or, you know, drug possession type cases where perhaps possession is at issue. Same with mere association on page 30. All of these, since there's only one perpetrator at issue here, I don't really see as being at play.
No objection.
no objection.
All right, so 28, 29, and 30 are gone. And then we move into the specific counts at issue. We got malice murder. I would include the jurisdiction without justification, but strike the without excuse, without mitigation. And then the remainder of it appears to be the pattern charge. After that, on page 32, we have the pattern charge for premeditation. We have the pattern charge for motive. We have felony murder, which is tailored to the indictment. So I would give that as outlined here.
It's not on the armed robbery, Your Honor. It's only on the aggravated assault.
Good catch. All right, so we're going to strike armed robbery and just say aggravated assault. And similarly, on page 35, we will strike armed robbery.
And for page 34, I would, the word felonies is plural.
Yeah. So that'll be as a felony
The 34?
Yeah.
on page 34.
Oh, that's.
All right, on 36, since neither party has requested voluntary, then I will strike that from the packet along with 36 and 37, along with 38, combat by agreement. That takes us to page 39. We have aggravated assault. The aggravated assault in this case is alleged to have been by shooting at with a deadly weapon, which looks like it matches this charge, so we would be good there. 40 would be the accompanying deadly weapon definition on page 40. Page 41. We had the possession of a firearm during the commission.
All charges listed.
They're all listed, yeah.
And now when it's murder, felony murder, and ag assault and armed robbery in that one. So 41 appears tailored to the indictment. And then we have on page 42, the pattern charge for armed robbery. We've got one parenthetical here. Let's see how it's indicted. It's indicted as from the person and immediate presence of Alejandro Brown. So I would just add in between the parenthetical or and give both phrases. Anything else on page 42? Okay, well, here we go. We got a non-pattern request for immediate presence. Actually, we got a couple of these.
Okay, hold on.
All right. I don't know about that.
That's what it says. That's what the law says.
No.
All right, if you want to be heard on these,
I object.
let's state on 40, page 43 and 44, you've got these non-pattern charges. If you want to add something on that, feel free.
State, you said?
Let's start with the state and then I'll pass it over.
Yes, Your Honor, I think specifically on 43, I mean, we can tailor the language, but that comes strict directly from that case law. It's been my experience that juries don't understand immediate presence and it needs to be explained what immediate presence is. And as you know, legal terms could be difficult. So these three cases explain what immediate presence is. If we want to tailor it, I heard Ms. Fagan say stretches the part where it says stretches fairly far, maybe too much. I'll be willing to talk about that, but I do think we need something that talks about immediate presence.
Okay, Ms. Fagan.
Immediate presence in health is not a legal term. Those words, immediate presence, those are normal English words. My issue with this is that these are all cases that are older than the rules that we even apply right now.
Well, I grant you that, but I had been trying to pull this while you were making your directed verdict. And the most recent thing I could find, not too much of a deep dive. I mean, this fairly far language is being quoted up until, as far as I can see, as recent as 2022 from the Georgia Court of Appeals.
But that was what was charged to the jury.
I understand that's the distinction, but that. So the age of that language is not necessarily my stopping point, but feel free to keep. What else would you like to add there? Just that you think the immediate presence is sufficient?
Well, right, I oppose the entire charge. Are you finding cases that use this charge?
Haven't gotten that far now. So, I mean, it is almost kind of the fairly far. I don't really love the verbiage there. It is one that's been repeated again and again. My inclination right now is to not give it as part of the initial charge. And if the jury comes back with questions about it, then we kind of reopen this whole discussion. And if I need to add clarifying language based on their questions, then perhaps that's where we could revisit the issue.
Can I argue it?
I'm sorry?
Can I argue this then? Am I allowed to?
You're allowed to argue it. I don't think you're allowed to refer to case law.
Okay.
Right? You're not supposed to be quoting from cases and saying this is what the law is. But certainly you can be arguing about what immediate presence means as far as the state understands it. And then if that becomes a sticking point for the jury, I may very well, after having taken a closer look at this case law and see if a jury's been charged on this or if some other definition has been upheld, add that clarifying instruction once we're in the deliberations. Any thoughts or additional thing to add on that?
I'm not seeking to be the guinea pig of
Yeah.
this very charge.
Yeah. Okay. All right. So right now, I would not give the non-pattern charge on 43. And moving on to page 44, we have a kind of a similar armed robbery related non-pattern charge. And this is more talking about even if the victim is incapacitated when the taking occurs. Ms. Fagan?
They were.
But not read.
Yeah, he read them.
Both of these?
I don't
He
think
read
so.
both of them.
I
I know you
I
argued
moved
against
through.
it, but he did, he did. We argued about it.
This one, because the language is a little more precise, I'm not as wary of it.
They were incapacitated, yeah.
Was that?
Because, and it just goes back to,
That goes
it's
more.
what, it's what I argued, well, anyway.
All right, let's just see where we are with it. Ms. Fagan, just generally,
So like, okay, so first of all, intent alone is just a piece of armed robbery, right? There's more elements to armed robbery than just the intent. This indicates that as long as you have the intention at any time, like I understand like the intention argument, but this isn't really focusing so much on intention as it is the presence, in my opinion. So it says that a conviction for armed robbery is authorized regardless of when the intent. So I would want it tailored more towards that it's just about intent, not about even that something was taken. Because the purpose is that it was an intent to rob, right? So this includes intent and action within one state.
okay.
Intent to take, is
Right.
that what you're saying?
Fine.
It's an intent to take, doesn't do.
But this is intention and action all in one.
So the robbery intention is the intent to commit a theft. And so perhaps taking your suggestion, if it's more explicit there, when the intent, well, I mean, intent to take does really seem to,
Right, so if it starts with a conviction. Conviction for armed robbery is authorized regardless of when the intent to take the person's property arose. I mean, I'm requesting to start at a conviction and end and place a period at arose. Because this is, like, there's three things going on in this pattern.
sure.
Intent, action, and the victim state.
All right, so it would read, a conviction for armed robbery is authorized regardless of when the intent to take the person's property arose, whether the victim was incapacitated, and even if the victim was killed instantly.
I mean, I'm okay with that.
I mean, we could also just separate them out so it's not saying as much. I mean, the next sentence could be, the theft may be completed after force was employed against a person. And then that's a separate sentence, kind of.
And I still think they go together. You're saying that you don't think they go together.
I'm saying you labeled this as a non-pattern state's request for the intent to commit robbery. So there's intention, there's action, and there's the victim's state. And I'm saying I don't think it's right to put all three of those issues in one pattern that's just labeled an intent to commit
It's not gonna be
robbery.
labeled, though.
I understand. I'm talking about though, right, you labeled it one, but then hit three things in one.
Maybe I don't understand. I think it's still the intent to commit the robbery.
I mean, if it's just making the concepts clearer, then
So
we can divide it out potentially.
right, so I object to the entirety.
Yeah.
In the event that it's coming in, I think that then the purpose that it's labeled for is all that it should be tailored to, which is the intent to commit robbery. I don't even know why this isn't covered in the intent pattern.
Fortunately, it's not.
I mean, it's just not part of armed robbery.
It's not part of it.
But what's different? The intent,
That it could be,
different?
it could happen after somebody is killed or incapacitated.
But within the intent. All right, hold on. Okay, so the armed robbery charge requires with the intent to commit theft, right? So not even the intent to commit robbery, just the intent to commit theft. And the intent charge. I mean, I think the intent pattern covers it.
You're saying like the general intent pattern?
That's right. So the fourth element of armed robbery, page 42, says that one of the elements the state must prove beyond a reasonable doubt is with the intent to commit theft. The pattern on page 25 indicates that they have to prove that my client had this intention, but the intent to commit theft doesn't have anything to do with when it happens or what was going on with the victim. Intent isn't intent. It's not
It could be
different intent.
after, but what this is saying, it could be after. That's what it's saying. It can be formed, they're incapacitated. And that's not what any of these patterns say.
Okay. All right. Well, I think we've got your concerns preserved for the record, Ms. Fagan. Because armed robbery contains so many elements and it comes in so many variations of how it can occur. I mean, I think there could be a legitimate issue, as I think you raised in the directed verdict, of what order these things have to happen in. And what the case law has pointed out, that it's not all simultaneously and that they can happen in different orders. There can be the using of offensive weapon and then a taking. And the intent can happen after the use of the offensive weapon. I think that's the point that this charge is trying to show, is that it's not just 1, 2, 3, 4 in that order. And so as a matter of case law, I'll take a look. But I don't think we're ever going to be able to definitively answer whether it's been used. If it's really just, we're going to know if it's ever been challenged on appeal. I'll look for that over the break, but the purpose of non-pattern charges is that they can play a role if they're supported by the evidence and then they're needed for the arguments. If part of the arguments at closing are going to be that an armed robbery didn't happen because here's what an armed robbery is, then this is an appropriate non-pattern charge.
Make the record clear, the argument for directed verdict had nothing to do with intent. The only argument made was present.
The immediate presence and the proximity. All right.
Which I'm sorry, Tim, that makes me go back to immediate presence, because if she's then arguing on
right.
directed verdict that there was an issue with immediate presence, why would we think that this jury would not have those same questions about immediate presence? That's why I think the immediate presence charge is needed.
I'll look at it over the break.
Okay.
And I need to find some more precise language if there's any that exists, and go from there. If it's just kind of, if the courts have just kind of been going in a case by case, hey, this is good enough for us without really giving us any more guidance other than it can be fairly far, it can be broad, then I think that's just going to rest on, the enlightened conscience of the jury. But I'm going to take a close look to it. I may still include one or both. So objections noted. Page 45, we have theft by taking. This would be a lesser. Is there any request for this lesser? I just included it based on what I'd heard. Any from the state?
No.
Ms. Fagan?
I haven't talked to my client about this one. Can we come back to that?
We can save it to the end and take a few moments. So if that's the case, then we'll skip to 48. We've got a non-pattern request on conjunctive, disjunctive.
I think there's something, in one of the pattern charges on this actually.
I think there is a pattern charge on
Yeah,
this.
I think there's, and
And is there a disjunctive that we're worried about or that actually
No.
exists in this indictment? Is there an and or?
the and or an indictment for, where is it? We just said it, the armed robbery. But I think in your pattern, you say or. So I just wanted to make sure.
Do you still want that pattern charge on wherever it exists? And once we find it on the and or distinction?
Yes, please. The pattern one would
Okay.
work, Your Honor.
All right, so we'll find the pattern charge on that. We'll include it. Moving on, 49 affirmative defenses. That's the intro pattern charge, which I'll give. We get to the core of self-defense on page 50. All right, and so when it lists the felonies that would be applicable, first of all, on page 50, I would strike a third person. I don't think there's any indication here that there's defense of a third person.
Or because of defense of Jabari and Penny not having firearms, who don't run until.
Okay. So then we would say, or a third person on that. And are we saying that he's trying to prevent the commission of a forcible felony here? All right. So we would just add aggravated assault in the blank. Any input from the state on that? Okay. We've got the defendant not being justified if he, and some of these may not apply. We've got is attempting to commit and fleeing after committing a felony. Is there any contention the state believes that's applicable here?
I think he was fleeing from the attempt to commit and fleeing.
This is where self-defense would not be justified because he committed a felony.
I think the armed robbery, right,
But I think this,
is fleeing. Oh, well, no, it doesn't, no,
okay, because,
doesn't work.
right, all right, state's striking the second exception there. We've got the initial aggressor, and then we've gotten combat agreement, but it sounds like no one's pursuing the combat by agreement theory, so I would strike that one. So that's the fourth. So we would only have the provokes and initial aggressor exceptions. All right, page 51, reasonable beliefs. Pattern charge, which I would give. Page 52, no duty to retreat. Pattern charge. 53, threats justifying a homicide. I would probably just give all of the parentheticals here. Any issues there?
No, Your Honor.
Okay.
Bench note is applicable as well.
So you want to add in a forcible felony as a felony that involves use of force or violence against another? And would we say murder and okay, we'll say aggravated assault. So we'll include that bench note. 54, we've got excessive force. We'll include both parentheticals. 55 is revenge. I think we would give all 4 parentheticals there since they're all at issue. You're saying just generally revenge. All right, Ms. Russell.
It's been put into evidence because your client testified that, and I would make the argument that at some point he believed that threats were made to him. And so when you see the victim or see the defendant see each other, that those threats were so bad, I guess, that there would need to be some sort of revenge. So I think they are applicable. I think revenge is applicable.
All right, Ms. Fagan, any other thoughts?
I don't think avenging a past wrong has been proved.
All right, well, using the slight evidence standard and the circumstances raised here, I think it's a inference a jury could make, and it's an argument the state could make validly, so I'll include it. I won't include the italicized forcible felony definition. We would have already had that in a prior charge. And then we have page 56, venue generally. I'll include the parenthetical about Fulton County. And this is pattern charge. Page 57. I've kind of wondered about page 57, actually. I know it's the pattern charge, but because we give them a verdict form that tells them what to check, I've always wondered if that actually is still applicable. Is there still a request for 57 when the verdict form, which I think I have a copy printed out for you? Not yet, I'll get it. It's gonna just be a box checking and not a, I don't know.
They're writing it.
Yeah, them writing it out.
I can't say I've had a case that it was.
Right, I know, but I just think it's when we just reflexively put in, because maybe they just used to write it on a piece of paper instead of, we kind of make it a little easier for them now.
Your verdict form, they just check guilty or not guilty.
Yeah, we'll have it, I'll print it out for you here. Oh, I think I can. Let's see.
Do all this to propose it still. You got it.
All right, coming back to that, the remainder of the charges all appear to be pattern charges. So I'd give them all. And so while I'm printing up the verdict form, why don't y'all confer about the lesser on theft by taking, and we can return to that one.
Actually, I probably can do it. Oh, I can't get on Odyssey, so I can't do it. The indictment.
No lesser included.
All right. Say what? We're still on the record. And so there being no request for the theft by taking, then I'll strike page 45, 46, and 47. All right, counsel, here's a proposed verdict form if you want to take a look. You can take that.
The reason that only count one has a murder.
Yeah.
Because if there was a lesser, we would make that distinguishing, but I'll strike that since we have no lessers. Any other concerns with the verdict form other than cleaning up count one? From the state?
No, Your Honor.
Okay, Ms. Fagan?
No, Your Honor.
And then again, I don't really feel strongly about it, but do we want page 57 where it talks about how you're supposed to fill out a verdict form? Do we want that in? Do we want that out? Any position from the state?
I have no position.
Ms. Fagan?
I mean, I would stick to the pattern.
Then we'll leave it in. All right. So with that, I'll take a look at the armed robbery language over the break. We'll have a consolidated version for you before we go into closings. And why don't we shoot for like 1:15? If you wanted to do, we could do 1:30 even. I don't know what y'all think. We want to do 1:30? I think we warned the jury this would take some time. So let's just do 1:30. If you're back earlier, I should have the final pattern charges for you and some guidance on what to expect there. And is there anything else we need to take before recessing?
How late does the court anticipate letting them go today?
So I'm assuming if y'all take about an hour for closings, again, you have a right to 2 hours. So I don't know if you're going to need more than that. Do you? I don't know if you.
We used 2 hours last time.
Did I?
Yes.
That's true. I could see that. So it usually takes me about 20 minutes to charge the jury. I think they could. You've already got the exhibits lined up. I would say conservatively they could get this case by 4 o'clock. So they'd have an hour if we start at 1:30. And look, at 5 o'clock, I'll check in with them. And if they're saying, wait, don't send us home yet, then we could stick with it until closer to 6. But otherwise, if we take their temperature closer to 5, that'll kind of determine everything. All right. Nothing else then. We'll be in recess till 1:30. Come back earlier if you feel ready to go. Here's court's exhibit 1.
I don't need that long.
Drop the
Deputy,
record.
what's the chances I can stay, work in that room? Can I work in that room?
Here's mine.
Tell me. Are you working in that?
I'll go back to my office. That's okay.
Yeah, I know. We're doing the swearing
Why
in.
would you give her the chance to
Sir.
in the room before me? and
Yeah,
she-
of course. Let me come on down.
Yeah. Yeah.
Yeah,
Right.
we'll give it
I'm like, hold on, wow, explain that one to me. Do you?
I went in there last time.
Appreciate it. And the door, this door can stay locked, but the main door can be open? Sure. Not good all the time? Okay. Nah,
Exhilarating.
all right, because I'm gonna use the restroom before I start working. Is that cool?
reiterate the rules, as far as they can't have their emotions. You know, they can't say they didn't know. But we had to, I just had a child and a person. That's an issue. Thing. I took it and you started off with I go back to work this week. You guys just let me know. I suppose. My wife around. Say brown somebody. Being seated, court will come to order. Throw that together.
So you have a stapler down there? I think there's one right over here somewhere. Yeah. Speaking. Yes, you. For attorneys. Commissioner, while you're sitting here. Did ask about.
Another set of rules in the code room. And if you Halloween. I know water, I bring your own water.
I gotta go.
No weed, really no talking to. Yeah, talk, what the judge is on. But you guys been doing some hands. I've been doing good too, son. Appreciate it.
Thank you.
So videos. Y'all had another copy. Is this what you played?
That's exactly what we're doing.
Yeah, it's just copied right onto that.
It's not playing on either of our laptops.
Probably because of Kodak.
You need VLC? You have VLC on there?
Is that a media player?
Mhm.
Okay, I'll look into that.
You wanna bring it out and then we can, or we can do it after, so we can try to.
I'll relay that to
Okay, yeah, VLC is how I.
okay.
It's Boyd, Mr. Boyd back there?
Ms. Fortis?
No, Mr. Boyd. He back there.
Who?
Mr. Boyd.
Oh, no.
All right, you ready? Anything you can?
Okay. Yes.
Let's look in. Yeah. Find it. Okay. That was Detective or Lieutenant Nelson. All right, tell me when you're, let me know when you're ready. All right, let's go back on the record. We have Mr. Young present and all counsel. And let me start with, I've got now the consolidated charge marked as Court's Exhibit 2. This would be the one that I would plan to send back with the jury, and I'll address the two outstanding issues we'd had, which were the state's request for non-pattern charges. On the first immediate presence, looking closer at the case law, I did find some cases where it had been approved or at least reviewed by the Court of Appeals and there was no error found. And I'm looking at Tanksley versus the state, 323 Georgia Appeals 299 from 2013. It was a plain error review, but they also made a point of saying legal error, if any. And essentially the language I took from that case is exactly what I've now plugged into on page 6 of the consolidated charges. And then I'll just note there was another case that upheld very similar language in Sweet versus the state, 304 Georgia Appeals 474. That was a robbery by sudden snatching case, but the same principle applies. And they said it was a no error. So that wasn't even plain error review. That's on the immediate presence issue. On the other pattern charge by the state, which was more about intent and when it can be formed and the incapacitation, I didn't find anything that had all of those different aspects kind of combined together at once. There's different sentences throughout the case law that make those points, but in that phrasing, I did not find it. And I, it kind of occurred to me as well that the way the state's request is put, it kind of says intent can be formed at any point prior. So you could read that in a literal sense that it could come, a week before potentially. So I wasn't wild about the phrasing there. And so I didn't include it in the final charge. What I would say is that if, as I mentioned before, the jury ends up coming back with a question on those points because it becomes an issue because of what's argued during closings, I'll just reserve the right to expound upon the charges and further the definition of armed robbery, which I believe it's within the court's discretion to do, and to take a closer look on what the issue might be that they have. Counsel can make their arguments in closings without providing legal citations, and we'll just take it from there. So based on what you've been able to see, everything else in the consolidated version should be as we discussed during the charge conference. So other than the objections already noted, is there anything else to have or to make on the record as it relates to now Court's Exhibit 2, which is the final consolidated version of the charge? I'll start with the state.
Oh, Your Honor.
No serious issues. I'm not sure if the court wants grammar issues.
Oh, you just want to hurt my ego? Sure. What do we
Well,
have?
I'm just saying, so on page 3, 1, 2, 3, fourth paragraph from the bottom. I think there should be a the before defendant, the last line.
Okay.
No, but I don't have it right now.
What'd you say?
It's seen one more similar, smallish.
Oh, small.
Sometimes things like that, I'm just going to
Fix as you go.
say in real time there. So rather than correcting course exhibit 2, I'll just note that and read that. Okay, not hearing any other concerns at the moment, then I think we would move onward. Again, I've got the verdict form that y'all looked at previously, and so that's there ready to go as well. And we're still working on potentially giving them that laptop. Maybe we can address that at the end of closings. So with that, is there anything else we need to take up before bringing in the jury? Ms. Russell? All right, Ms. Fagan? Okay, again, just for council's use, even if it's not necessary, I'll have the clocks running the time for everybody. Ms. Russell, is the state electing to begin the closing arguments?
Yes, Judge.
All right, if you could go ahead and pull up your PowerPoint as we bring in the jury.
Oh, heels. Mm-mm. I ain't going that way. Mm-mm. Not today. Ain't happening. Why is it that box? It's gonna go on. There it is.
Ms. Smith, here you go. Here's one you can read along to. And there's the verdict form too. Well, with your eyeball. You need to keep this up. I'm going to do 300 words a minute.
All right, for jury.
Thank you, Deputy Scott. Thank you, members of the jury, for your patience. As I indicated before we broke, we are now ready for closing arguments. The state, because it has the burden of proof, has the right to both open and conclude closing arguments. So, Ms. Russell, the floor is yours.
Thank you. Oh,
Oh,
okay. Number 745. Alejandro Brown. Number 745. 2009. And he will forever be 25 years old. Because of the defendant, Airieon Young. Make do what we got. Stop sharing. Okay, sorry about that, ladies and gentlemen. Clearly, technology. Works at here. 745, all right? 745, and he will forever be 745, okay? He will forever be 25 years old because of the defendant, Airieon. And today, ladies and gentlemen, right? And yesterday and the day before, we chose you. We chose you because of your common sense and your ability to follow the law, listen to the evidence and the facts, apply the law and the facts together. Okay? That's why we chose. And in the beginning, because I get to go twice, in the beginning of this entire closing argument, I am going to go over the law. I'll weave in some facts, but then I'll go over the law. After Ms. Fagan goes, I will then get up and have another chance to speak to you about more facts that happened and that came out. Okay? The only person that had the right to defend themselves was Alejandro Brown. It's the only person. So when you're thinking about this case, when you go back to the jury room, when you are deliberating with your fellow jurors, you think about Alejandro Brown being the victim and him having the right to defend himself this entire time. Okay? Counsel in opening talked about the right to live. That was her thing. This is about the right to live. Alejandro Brown had the right to live. He had the right to live. And that was taken away by Airieon. Okay? The defendant does not get to play and determine who decides, or if he decides who lives and who dies, because of some Instagram phone call that happened 8 months prior. That's not how this works. That's not what the law is going to tell you. Okay? So we have the defendant being the aggressor. Okay? The defendant was the aggressor. And again, when you go back in the jury room, I want you to remember, victim had the right to defend himself. Defendant had no right to do that because he was the aggressor. He provoked this. He was the initial provoker. Okay? Defense also harped on in opening about 8 seconds. It's 8 seconds. 8 seconds where the defendant saw the victim and didn't shoot. I submit to you, ladies and gentlemen, that it doesn't matter about those particular 8 seconds when he could have shot. Why? Because Alejandro Brown's back was turned. He's the one who recognized the victim, and I said he, the defendant. He's the one, right, that kept going into his pocket, right? He's the one who pulled out his gun, said words to the victim, and decided that he was going to play God. Okay? I'm gonna pull my screen. So I want to talk to you a little bit about a juror's duty, all right? And what is a juror's duty, okay? A juror's duty is for you to use your common sense and reason, okay? You are to consider only the evidence presented. And you, ladies and gentlemen, decide which evidence you want to which evidence you want to hear. It's up for you to decide. And I say what you want to hear, but what you are to consider. You are the fact finder. Right? When we chose you, we were looking for a fair and impartial jury. Right? That's what you all were chosen to do. Okay? You kept asking that question. You kept hearing it over and over and over again. And I kept saying, well, this is going to get annoying, but I'm going to ask you these questions. Can you be fair and impartial? And each one of you all said that you could be. You are to seek the truth, and you're not to seek any doubt, not to go hunting and seeking doubt. You're to only seek the truth. Okay? So what is a juror's duty? Right? And I have this circle here, and this describes what your duty is. Okay? You are not to concern yourself with anything on the outside of this circle. Nothing. Okay? You're to only concern yourself with what's inside this circle. Okay? The law, testimony of experts, witnesses, forensic evidence, elements of the crime, and common sense. That's what you are to consider. You're not to consider passion, sympathy for the defendant. I understand he got up here and cried, but you're not to consider that. That's not what you were chosen to do. And the judge is going to give you that law about what you are supposed to look at. And that's not one of them. No prejudice or no hard feelings. If you have prejudice of any sort against anybody, you're unhappy with the police, if you disagree with the law, nope. You were chosen because you said that you could follow this law that the judge gives you. Okay? You're not to consider punishment either. Okay, so let's talk about the law a little bit. First, we're going to talk about the presumption of innocence. I don't know why there's a blank in there. Okay. All right, so and you'll get this law that at the beginning of this trial, the defendant is presumed innocent. But as soon as the state rested, that presumption that was proven, his guilt was proven beyond a reasonable doubt. Okay? Soon as we rested, soon as the evidence came in from the state, his guilt was proven. Furthermore, when he got on the stand and told his side of what supposedly happened, it was proven even more. Okay? Next thing we're going to talk about is beyond a reasonable doubt. What does that mean? Okay? Beyond a reasonable doubt is not beyond all doubt. Okay? It's not beyond all doubt. It's not to a mathematical certainty. It's not vague or arbitrary. It's a reasonable doubt. And you're going to hear a lot about reasonableness. What is reasonable? Okay? That's for you to decide, right? But you're going to hear what reasonable is. Okay? Excuse me, you'll hear reasonable a lot. We understand as a state that we have to prove every element of this, of every charge. Okay? And there's 5 charges here. We understand that we have to prove that beyond a reasonable doubt. We're going to go a little bit more into the charges, but I'll give you an analogy a little bit later on about what reasonable doubt is. Okay? Also, reasonable doubt is based on your common sense and just reason. Okay? Uh-oh. Okay. Direct and circumstantial evidence. I know you all probably have heard this over time. What is direct and circumstantial evidence? Well, it's proof of facts, circumstances by direct evidence. That's circumstantial evidence, from which you may infer other related or connected facts that are reasonable and justified in light of your experience. Okay. That's a lot of words. What does that mean? That's going to be a part of the law that you get. Again, I'm going to give you an analogy in a few minutes about it. But I want to make sure that you all at least have the law, that you understand it, and I'll go through it with my analogy, okay? One of the things that, when you think about direct and circumstantial evidence, is that it has to be consistent with the theory of guilt, but also exclude every reasonable theory other than the guilt of the accused. All right, what is that? What does all that mean? And I'm gonna go to it, okay? All right. Right. So I have a little house here, right? To explain reasonable doubt, circumstantial evidence, direct evidence. And how I explain it is this. So one night in January, you are watching the news, and on the news, the meteorologist comes on and says, ladies and gentlemen out there, it's going to snow tomorrow. And you say, okay, I mean, it's January, it's probable, but there, you know, it's been like clear. You know, it's cold, but you know, okay. So at some point, you go upstairs, well, not here, but you go to your bedroom, you lay down, tuck yourself in, and then you wake up the next morning. And when you wake up the next morning, you pull back the covers and you say, oof, it's kind of chilly in this house because you didn't turn on the heat last night. So you go and you walk outside. And when you walk outside, you open the door and you see snow. You see snow everywhere. You see snow on the ground. You see snow on the house. You see snow on the houses around you. And you're like, it snowed. It's cold out here, right? And so while you're outside, you're just looking around. You look to your left, and when you look to your left, you see a neighbor outside. Let's call him Crazy Bob, okay? And Crazy Bob says to you, hey neighbor, look what those aliens came down and did last night. They blasted snow everywhere. And you say, okay, Crazy Bob. And then you go and you still are checking out the snow, making sure everything is okay with your car because you have it parked outside. And then you have a neighbor to the right of you. Let's call her Crazy Sue. Okay. And Crazy Sue says to you, hey neighbor, how you doing? That movie set director came here and they just blasted snow everywhere. They're gonna have a movie here, a Hallmark movie. It's gonna be a Hallmark Christmas movie here. And you say, okay, all right. The movie set people came and put snow everywhere? And she goes, yeah, okay. And you go back in your house and you sit down in front of the television. You don't turn it on, but you sit there and you're thinking about those two stories. And you think about Crazy Bob's story and you say to yourself, well, could aliens have come down? No, that's just not probable, right? Not only is it not probable, it's just not reasonable, right? It's not reasonable because, well, last night the meteorologist said it's, and though when I went to bed, I didn't see it snowing, right? He said it was gonna snow. He's an expert in his field. I go outside and it's the right temperature for snow. Heck, it's January, right? You say, nah, that's not probable. So you still are sitting there thinking like, well, maybe Crazy Sue is saying, you know, what she said is right. Maybe her side of what happened is right. Maybe movie set director did come out. But then you think to yourself, no, that's not probable either. That's not even reasonable. Well, why is it not reasonable? Well, it's not reasonable because all of the things, the circumstantial evidence of it being cold out, right? You seeing the snow, you see the snow on top of houses, you see a car drive by and it has snow on it, and there's snow everywhere in your city. It's not like there's just snow on your particular street, right? So the circumstantial evidence in that, right, is that even though you didn't see it, okay, right, even though you didn't see the snow, you know that there's snow on top of the houses and on top of cars, right? The direct evidence is from the meteorologist who told you it was gonna snow, right? Direct evidence is when you went out and you saw the snow and you felt it underneath the crunch underneath your feet. That's direct evidence, right? I explained reasonable doubt here, right? Just because there's a story of something from Crazy Bob or Crazy Sue about how this snow got here doesn't necessarily make it reasonable. And so when you go back into the jury room and you look at the evidence in this particular case, you think about whether or not it's reasonable to what you have seen, okay? What you have seen, right, is this video of this murder taking place, right? And you have to think about each step and what this defendant told you about what he was thinking and why he did the things he did and whether or not that was reasonable. And I submit to you, ladies and gentlemen, it was not reasonable, okay? That him claiming self-defense is not reasonable. All right? So that's reasonable doubt, circumstantial evidence, and direct evidence in a nutshell. All right. Intent, okay? Intent may be shown in many ways, right? It may be shown from the proven circumstances or by acts and conduct, or it may be inferred from the natural and necessary consequences of the act, right? So I specifically like inferred from the proven circumstances or by acts and conduct. I told you about before, during, and after, right? Before, during, and after. I want you to look at the before, at the during, and the after. The acts of this defendant show his intent. They prove his intent was to murder. All right? You look at all of those acts, you take all of that into consideration when you are deciding that he is guilty of murder. All right? Credibility of the witnesses. It's for you to determine the credibility of the witnesses in deciding this case. You consider all the facts and circumstances, right? The biggest part or the point I want to highlight is one, the probability or improbability of the testimony, the interest or lack of interest in the outcome of the case. All right? For you to decide. Well, why is that important, right? Because I think credibility from defendant is huge, right? The probability or improbability. Is it reasonable to believe, right, that 8 months prior to this, Alejandro Brown Instagram called this defendant? Okay, maybe in your head you may say, okay, that could be reasonable. Maybe not, right? Because where are the records? There was none of that shown, right? It was over a girl that this defendant didn't even know, right? And it's just his interest in this, of course, right? Let me make up a story about something that happened 8 months ago, about an Instagram call. It just doesn't make sense, right? So go back to that reasonableness in your head when you're deciding whether or not you believe the credibility of this defendant. And we'll go a little bit more into detail about some of his story and what he has said. You'll get a charge about prior difficulties, right? So, and I kind of hit on this when we talked about the prior difficulty, if you believe it, because it's up for you to decide whether or not you believe that fact, that Alejandro Brown actually did call this defendant, okay? But in that very same charge that you'll get, and you'll get a copy of the charges, reasonableness of any alleged fears by the defendant. Is it reasonable for this defendant to be afraid of Alejandro Brown, right? 8 months later from an Instagram phone call. Is that reasonable? Is it reasonable that for him to be afraid of, to fear Alejandro Brown, when Alejandro Brown walks in to this convenience store and doesn't even see him? Is that reasonable? No, that's not a reasonable fear. And it's not the fear of this defendant, it's a reasonable person. Okay? It's a reasonable person standard. I know he said that, oh, I was afraid, but that's not a reasonable person. Are you? You all decide. Okay? And I submit to you that he was not being reasonable. Okay. Character of the defendant. All right, you'll get a charge about this. Evidence of the defendant's character of lawfulness. You heard testimony from this defendant that he hadn't been in any trouble before. Okay. Okay. Does that show anything? Does that prove that he didn't shoot this man? That doesn't show anything. Just because you haven't been in trouble before, right? That does not prove anything, right? And I say he hasn't been in any trouble, but the lawfulness. He said, oh, I haven't been in any trouble before, during, or after any of it. You are the ones that consider character evidence, okay? Whether you have a reasonable doubt about the defendants, you take that into consideration. I submit to you, ladies and gentlemen, that just because you haven't been in trouble before doesn't mean that you cannot murder somebody. Okay? All right, so let's get into the crimes charge. The first one, or the first thing I want to talk to you about, and again, the law plus the facts equals guilt. Can't remember, I don't think we have a lawyer on here, but at some point in law school, this is how we learn how to break down crimes, this is how we learn how to do it. You get the law, you apply the facts, and you determine whether or not the facts and the law will get guilty or not guilty. All right, this is just how you learn. All right, and I'm gonna break that down for you all so you can understand. All right, so count one is murder. When a person unlawfully and with malice aforethought causes the death of a human being. All right, malice can be expressed, the deliberate intention to kill, or implied, which implied is no significant provocation in all circumstances showing abandon and malignant heart. That's a lot. What does that mean? I'll talk about it in a second. But I want to give you this first. How do we break that down? Okay. All right. So the law is going to be in yellow, right? And when you get that packet of the law, when you get that packet, you'll see murder as a charge, right? You'll get that charge. And what you do is you take it and you break it down. When a person, that's simple, a person, Airieon Young, you plug in the facts, unlawfully, non-accident, not justified. It's actually just not justified. That won't be in there, but not justified. We'll talk about that. With malice aforethought. So malice aforethought, we said, is express malice or implied malice. So express malice, meaning you intended to kill. Express malice is he fired his gun at least 14 times. He intended to kill this person. He intended to injure and kill Alejandro Brown. When you shoot 14 times, that ain't an accident. That's express malice, okay? Right? Implied malice. Implied malice, when you are preparing, right? Preparing, you're passing the drink, you say words, you're aggressive, you have your hand on your gun. That's implied. You are implying you are having the intent for something to go down and specifically to kill, okay? Last part is cause the death of a human being. Alejandro Brown is dead because of multiple gunshot wounds. We know that because of Dr. Geller. He died because of his gunshot wounds, That's why we brought Dr. Geller in. We didn't want to just show you these pictures and Alejandro Brown lying on the table. We didn't want to do that. But that's a part of beyond a reasonable doubt. We have to prove that the firearm, the multiple gunshots, we got to prove that that caused his death. Okay. And we've done that with Dr. Geller. All right. So when you go back there, and I'm going to go through each and every charge, but murder, you'll see it. It'll be on a piece of paper. Break it down like this. Just plug in the facts. Plug in the facts. And when you plug in these facts, you will see that you can find this defendant guilty of murder. Malice, right? So we talked about implied, we talked about express malice. Malice is not ill will or it's not hatred. You don't have to find that this defendant hated Alejandro Brown in order to find malice. That's not what this is. But it is the unlawful intention to kill without justification, without excuse or mitigation. Okay? Specifically without justification, that's what we have here. Because Airieon Young is claiming that he was justified in doing this. So we're saying that he was not justified. The state is saying he was not justified. So we have proven to you that he intended to kill and he was not justified in doing that. Okay? If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes a murder. Plain and simple. So it can be a blink like that. It can be that 8 seconds. It can be 1 second. Right? It can be in the time frame that he let off 14 shots. That's malice. Premeditation. Premeditation is not required. Okay? It's not required. We don't have to prove premeditation at all. However, I submit to you, ladies and gentlemen, that in those 8 seconds that he was waiting, that he noticed Alejandro Brown, that he put his hand in his pocket, and he was feeling and touching his gun, right then and there, he knew that he would do it. When he saw Alejandro Brown walk into the Chevron, premeditation at that point. Again, that's not anything that we have to prove. And I want to make sure that you all understand. Motive, no proof of motive is required also. So again, when I got up here in the beginning, in the openings, I said, I can't tell you why. I'm not going to be able to tell you why this happened. And to be quite honest, I still can't tell you why this happened, because a phone call from 8 months prior, that's not a reason to prepare somebody. It's not reasonable to kill somebody or to get prepared. We don't have to prove it. Okay? But through his intentions, through his looking at the before, the during, and the after, right? Looking at all three of those things, his intent was to kill Alejandro Brown. All right. Count 2 is felony murder. All right. This is count 2. So when a homicide is committed during the commission of a felony, there must be some sort of connection between the homicide and the felony being committed. Okay. Malice is not required for felony murder. All right. So let's break this down. Okay. And it's a little difficult because you'll see that felony murder is based on the aggravated assault with a deadly weapon. So count 2 is felony murder. Count 3 is aggravated assault with a deadly weapon. And I'm going to go back to the felony murder in a second, but I want to make sure that you understand that felony murder is you have a homicide, and that homicide was done because of the aggravated assault with a deadly weapon. That's felony murder. You don't have to prove malice with that. Okay, you don't have to prove express malice or implied malice. Ladies and gentlemen of the jury, what you have to decide is, was there a homicide? And was that homicide done during an aggravated assault with a deadly weapon? That's all for felony murder. Okay? But we got to prove, right? Aggravated assault with a deadly weapon. What is that? You must find the defendant committed the offense of aggravated assault and that the victim died during the commission of the aggravated assault. Does not matter whether, his death was intended or not. So we don't have to prove for felony murder that this defendant intended to kill. Okay, that's the difference. All you have to prove is that the aggravated assault he committed, he wanted to raise his firearm and shoot and injure Alejandro Brown with a deadly weapon. Okay? So how does that look? Again, let's do the law plus the facts. Right? When a homicide is committed, we know Alejandro is dead, right? During the commission of a felony, aggravated assault. Simple as that. It's as simple as that for felony murder. Okay? What is aggravated assault, though? So, when a person assaults another, right? To prove assault, the state does not have to prove that the other person is actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person with a deadly weapon. That's simple as that. Right? Person assaults another with a deadly weapon. That's it. And what that means, that second bullet point, to prove assault, the state does not have to prove that the other person was actually injured. If he raised his firearm, right, and he didn't shoot, that's evidence. However, he did shoot in this case, so that doesn't necessarily matter. All right. So how did we prove that? Okay. The law is in yellow when a person assaults another with a deadly weapon. And we're plugging in aggravated assault. Defendant, right? This defendant pointed a gun, shoots gun at Alejandro Brown. The deadly weapon, a firearm, handgun is a deadly weapon. You'll get that charge. A handgun is a deadly weapon. You saw it. There was a handgun. What's that? That's aggravated assault. Again, I did felony murder as well. So felony murder and aggravated assault, we just did. All right, on to count 4. Armed robbery. The defendant took another person's property from the immediate presence of another person by using an offensive weapon and with the intent to commit a theft. So I want to make sure that you all understand one thing, that just because the elements are broken down like this doesn't mean they have to chronologically go in this order, right? Because we saw, right, on the video that Airieon Young took another person's property, Alejandro Brown's property, after he used force. It doesn't have to go in this particular order, okay? So how do we prove this one? And I want to talk about immediate presence because that's the second element here. If what was taken was under the control or the victim's responsibility, the victim was not too far distant, right? So we saw Alejandro Brown have the gun, right? He dropped the gun to the side of him and he crawled outside, okay? It was his responsibility. That gun was his, right? Wasn't for anybody else to take, okay? It was in his immediate presence. It wasn't too far away. He went outside. Was not for anybody else to take, right? It was his responsibility. That's immediate presence, okay? And then I also want to, again, I already talked about kind of like the order, okay, of things. If theft was completed after force was employed against a person, a conviction for armed robbery is authorized, regardless of when the intent to take the person's property arose, whether the victim was incapacitated, even if the victim was killed. So one of the examples I like to give for this one, again, that's that order. That's what that means, right? An example I give for this one is person goes into the bank, right? And they go to withdraw money from the bank. And they look around and they're like, you know what? There's no security guard here, right? Their intention at first was to go into bank to withdraw money, right? Their intention changed at some point, okay? Right? And they pull out a gun, they shoot the clerk dies, the bank clerk dies, and then they grab the money, right? It doesn't have to be in the order of they ask for the money and then they shoot, right? It does not have to be in a specific order, okay? So that's the same thing in this particular case. It does not have to be in a specific order. Like you saw, Airieon went and took that firearm. He had committed some sort of force against Alejandro, and he took the firearm. I mean, he admitted that he did not return that firearm, okay? So what's the law? Took another person's property. Defendant took the gun of Alejandro Brown from the immediate presence of another person. Alejandro's gun was his responsibility, and he was not too far distant, okay? By using an offensive weapon, right? Defendant used a gun. Remember, he had his gun on him, okay? And he was able to take Alejandro Brown's gun with the intent to commit a theft. He did not return it. That's the intent to commit a theft, to take from somebody, okay? Okay. And count 5, possession of a firearm during the commission of a felony. All right. When a person has a firearm on or within arm's reach of this person during the commission of a felony, murder, felony murder, or aggravated assault. Simple as that. Okay. How do you prove that? State has proven this, right? When a person has a firearm on or within arm's reach, we know the defendant had a firearm, right? We saw him with the firearm. During the commission of a felony, murder, felony murder, aggravated assault. He committed murder, he committed felony murder, and he committed aggravated assault. Plug in those facts. Okay. Now I want to talk about justification, because a lot of these, right, these crimes, if you believe or if you find that the defendant was justified, then it would be a not guilty. But I submit to you that that's not the case here. He was not justified. The defendant was not justified. So a person is justified in using force that is intended or likely to cause death or great bodily harm only if that person reasonably, here it is, I told you, you'll continue to see it, reasonably. We talked about what reasonableness is. We talked about it, right? Was it reasonable for him to believe that Alejandro Brown was going to cause death or great bodily harm to him? No, because he was faced the other way. That just doesn't make sense. So it's not reasonable for him to believe that, or this defendant to believe that. Also with justification, right? You'll also get discharge, reasonable belief. And applying the law of self-defense, the defendant is justified to kill another person in defense of self, okay? The standard is whether the circumstances, all right, were such that they would excite not merely the fears of the defendant, but the fears of a reasonable person. So I want you to ask yourself, is it reasonable to be scared of a person that has their back turned towards you, that doesn't see you, that allegedly made threats to you 8 months prior? That's not reasonable. That's not reasonable for him to believe that, ladies and gentlemen. It just doesn't make sense. For the killing to be justified under the law, the accused must truly have acted under influence of these fears. No, he doesn't get there. He doesn't get there with what he told you on the stand today. With what you have seen on the video, he doesn't get there. Okay. Another. A person is not justified, and you'll get this, a person is not justified in using force. You can find the defendant guilty if you find that this defendant started, provokes the use of force against himself with intent to use such force as an excuse to inflict bodily harm upon himself. Right there. If he started it, he's not justified. It's plain and simple. Not only do you have if he started it, but if he was the initial aggressor. If he was the aggressor. Bam. That's what the law is going to say. He's not justified. And you, ladies and gentlemen, can find this defendant guilty, all the charges beyond a reasonable doubt. Okay? I spelled aggressor wrong. Yeah. Okay. You'll get a charge about excessive force. Right? So, the use of excessive force or unlawful force while acting in self-defense is not justifiable. And the defendant's conduct in this case will not be justified if you find that the force used exceeded that which the defendant reasonably believed was necessary to defend against the victim's use of unlawful force. Well, first of all, I think you have to find that the victim's use of force is unlawful, if any, right? That's what it says. His use of force wasn't unlawful. He had the right to do it. He had an initial aggressor. We had an aggressor behind him. And when he does turn around, there's 3 people standing behind him and somebody saying something to him and taking his gun out. Right there. So was it excessive? Absolutely. Because when Alejandro Brown walked in the Chevron, he didn't have a gun out. So why did the defendant think it was okay for him to start with his gun, start getting ready, getting prepared, having his gun in his hand? That's excessive. At no point in time was Alejandro Brown a threat. No point. Until the defendant started it. Until the defendant became the aggressor. No duty to retreat. All right. You'll get a law about no duty to retreat. A person who is not the aggressor, and that's the key word here, not the aggressor. A person who is not the aggressor is not required to retreat before being justified in using force he or she reasonably believes to be necessary. Well, the person that wasn't the aggressor was Alejandro Brown. So once he sees that Airieon Young is behind him, taking out a gun and saying words to him, which we'll get to those words in my next closing, but saying those words to him, right? He's not the aggressor, it's Airieon. So he's not required to retreat. Alejandro Brown is not required to retreat. Okay? Aggressor is the defendant. Again, no duty to retreat. However, the defendant had time to exit the store, go to the back of the store, walk away, and not say anything. Right? He had all of these opportunities to do that, and he did not do it. Revenge. you heard testimony from Airieon Young about him being threatened by Alejandro Brown. Again, you determine the credibility of that, the reasonableness of that. However, you'll get a charge as well that the defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. It's right there. He's not justified. I mean, he said that he threatened him over 8 months ago. Still not justified. Not justified to start pulling out guns to say something to him for something that happened 8 months ago. Okay? If you find beyond a reasonable doubt the defendant used force against the victim for the purpose of avenging a past wrong, right? Avenging that Alejandro Brown may have said something to him, right? Then you would be authorized to convict the defendant. Okay? You would be authorized to convict. Again, it's the state's burden, right? When justification defense is raised, the burden is on us to disprove it beyond a reasonable doubt. Disprove it. Think of the house with the snow, right? How do we disprove Crazy Bob, Crazy Sue's story? Through common sense, through reason, through the evidence, okay? State has disproved that. You saw it. You saw the video, right? You saw the Grady records. You saw all of these things. You have disproved that this is justified, okay? All of that evidence is used to disprove it beyond a reasonable doubt. Again, remember the law plus the facts, and that's how you're going to come out with a guilt. Right? Now I'm going to sit down. I have a few more analogies for you, okay, so that you can understand the law, and we will, okay, and so you can understand the law, and you can understand the facts with the law. But remember, this defendant was the aggressor and initiated his entire. Right.
Ms. Fagan, whenever you're ready.
All right. Good afternoon, everyone. You know, first and foremost, I want to say thank you because I know that everyone has their own lives, their own responsibilities, and their own places to be. And I appreciate that you've all been here, and not just been here, but you guys have been taking notes. I appreciate the attention that you've given this case because from the beginning, I explained that this case was serious, it was important, but it was simple because I mean, not for nothing, we spent more time just picking you than we did actual evidence, right? And now we're here and this is closing arguments. And remember in opening statements, I told you, and what Judge already told you was that everything we say is in evidence, right? In opening statements, we had the opportunity to tell you of what we thought the evidence would show. And now it's closing arguments. And so that's our chance to argue the law to you, right? But ultimately, you decide what the facts are. You decide how the facts apply to the law, and we are just looking to seek the truth. That is all that we are here for. Ladies and gentlemen, I said it's a simple case because this case is about that video. That's all this case is about. We spent time with like other witnesses, but ultimately the decision comes from the video, okay? So a little bit about process from here. So the state, we both get 2 hours. That's the law. We both get 2 hours for closing arguments. And the state gets to go first, and then I go, and the state gets to chew me up on the back end, right? And so on the back end, they're gonna be like, well, Ms. Fagan wants you to believe, and Ms. Fagan wants you to believe. This isn't about Ms. Fagan.
This isn't about Crazy Sue or Crazy Bob. This is about Airieon. That's what we're here for. So don't let analogies and storytelling affect you. Understand that, yes, it's our job to send, she works for the state, I work for my client, right? So we don't get to make our files, but this position is when we tell you how we believe you should apply the facts to the law, but you guys decide what the facts are and how the law applies. And that's why your position as jurors is so important in this case. So one of the things that I said from the beginning was simply that my client's actions were necessary. Now take out, say he didn't pull his gun, say he didn't touch his pocket. Ladies and gentlemen, if he had not, you saw from Alejandro Brown's body language and reaction time that he immediately was pulling an illegal gun. It had a switch on it. You can't buy them in stores for a reason. But not just that, when he immediately saw my client, he reacted. My client had time to go ahead and pull it back, but he didn't. He chose not to prepare, which isn't illegal. So then the state's like, well, passing his drink off, that's express malice. When? When is passing your drink express malice? Tapping your pockets, that's express malice. How? To be prepared? If you actually watch that video, you'll see that on the way in, my client puts his phone and everything in that same pocket. So, and watch it. I know, not for nothing, but I was the first one to even play the video. Because that video is everything. When Detective Baker took the stand, I went through the timeline with her because Detective Baker's gonna sit there and tell the truth. Good, bad, or ugly. She's gonna tell the truth. Now, Detective Nelson, who's the lead investigator on this case and clearly looking for convictions, she's the only one besides Ms. Russell that calls my client an aggressor. The only one, you know? So let's talk about how the law applies. Oh, and why? Wait, the state just said, I don't know why we're here. Why we are here is because Alejandro Brown pulled a gun out. If Alejandro Brown didn't pull a gun out, there is no evidence that my client would have. There's opportunity to. And so the law, and we'll go through the law, but the law is in my client's favor, and they have to prove his guilt. We don't just assume and presume against him because his actions show more than that. His actions show that what I said in my opening was that he's not a kid that shoots first and asks questions later. He had opportunity to just pull the gun and he didn't. So let's go through it. Okay, ladies and gentlemen, you were picked as our jurors because you agreed that you could be fair and impartial, that you would be able to listen to the evidence, determine what you believe to be fact, apply it to the law, and seek the truth. So now, after I go and then the state goes, and she still has an hour and 10 minutes, but after I go and then the state goes, the judge will read you this law, and then you will get the law in the back. So writing notes, you'll get this physically, word for word, okay? But I went through it while the state was going, and I made sure to identify the page and the paragraph, because this isn't about writing things in red and yellow. You determine how you apply the law, right? But this is where you find the law. And I don't take pieces of the law, and hopefully you'll see in your notes where they took pieces of the law. This is verbatim, okay? So verbatim, the burden of proof is not on my client, and it never shifts to him. He never even had to testify. He doesn't have to prove his innocence. The entirety of the burden is on the state. And so when the state says, well, we just needed to prove these elements, that's not what this law is about to show. What the law shows is that when an affirmative defense is raised, they have to disprove it beyond a reasonable doubt. Proof of elements of a crime and then disprove the affirmative defense. That's the law. So on page one, paragraph 6, you'll see the burden of proof. Intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. That's on page 4, paragraph 2. Intent to kill. Ladies and gentlemen, if he had that intent to kill, he could have shot him before the guy even had a chance to get off his 10 rounds. Or on the way out, he could have shot him again. What you'll see on the video is that when Alejandro Brown stopped shooting, because he's still shooting from the ground, shooting up. When he stopped shooting them, my client ceases too. No excessive force here. This is an act of necessity because like I said before, if he had it, it would be number 745. And you know, I specifically asked him, did you have the intent or motive to kill? And I said, did you have the intent or motive to rob the gentleman? And he said, I just want to make sure that he didn't shoot me. That's what he testified to. And you know, after he finished, the judge says, State, you want to put up some rebuttal evidence? They said no. Because his affirmative defense can't be disproven. Okay, so let's go through it. On page 4, paragraph 5, you'll find that there's no presumption of criminal intent. So that my client will not be presumed to have acted in criminal intent. Now to find criminal intent, you have to look at words, conduct, demeanor, and motive. But you don't just say, well, he must have acted with criminal intent. It doesn't work that way. That's just not how the law works. So words. So the words that the state wants to go through and what we'll show in this video is you can't hear my client. And we know there's sound because we hear the guy order the Newport shorts and we hear Frank in the background talking, but we know we can't hear my client, right? So then the question is credibility of whether or not you believe what he said. Okay, conduct. Conduct is the fact that he didn't, okay, he had 10 tiles. You can count the tiles. He had 10 tiles of feet between him and Mr. Brown. He could have pulled a gun. If he really knew, so he said he was in fear, right? And that's why he was grabbing a gun. If he knew the guy was going to, for sure, shoot him, why would he give him a chance? Right? He waited. He was like, well, let me see what you're going to do first. And he did exactly what the man said he would do. When he said, when I see you, I'm going to effing kill you, that is exactly what Mr. Brown did. On page 1, paragraph 3, the very beginning of the law is the presumption of innocence, that my client was presumed innocent until proven guilty, and that it stays with him until it's overcome by the state. That's the law. Your oath. Your oath requires that you decide the case based on the evidence, not your feelings, I agree with that, but the facts. And don't check your common sense and life experiences at the door. We ask each and every one of you specific questions. Have you ever been a victim of? What things were you dealing with from that? We asked if you knew anyone that had ever been arrested. We asked if anyone knew anyone that had ever been falsely accused. We asked who doesn't like firearms. And that's why I told you from the beginning, I didn't say that this case was a case about the right to live. I said this case was about the right not to die. That's what I said. This isn't about the right to bear arms. This is about the right not to die. So, like I said, anything I say is an evidence. Anything the state says is an evidence. The evidence was testimony, exhibits, and then there's direct and circumstantial evidence. This comes on page 2, paragraph 4. So for testimony, that's like when you guys are human lie detector tests. You believe or you don't believe what people say. Then you have the exhibits. I went through all the exhibits with the lead detective. Not one exhibit matters except that video, right? What does it matter about cell phones? We're saying we were there. We were at the gas station. We went to the hospital, right? What does it matter? Why put a warrant out for Jabari Johnson's mom who came and testified today? Put a warrant out for her yesterday for what? Right? And then we have, who else do we have? We had Detective West came in. Detective West said he didn't find anything illegal. We didn't hear
hear from any first responding officers. We didn't hear from anyone from crime scene, right? But we hear things that, I mean, the cell phone evidence, it doesn't even matter, right? It doesn't matter. That part isn't even in dispute. So then there's the difference between direct and circumstantial evidence. So direct evidence is like, I see, I heard, I felt, I tasted, direct, right? And then there's circumstantial evidence, things that you can connect together even though somebody didn't really see it. The problem with the circumstantial and direct evidence is that the evidence needs to prove beyond a reasonable doubt of guilt. But it also has to disprove any reasonable theory of innocence. And we'll get there because that's the law. But when cases start getting shaky, that's when analogies come into play. And that's a problem because we just need to stick to the facts. It's not about trying to eat to your emotions. So stories about how the snow fell, that doesn't matter. It's wasting time, right? And so other ones they might use, they might put up a picture of a puzzle and be like, ladies and gentlemen, we might not have all the pieces, but you still get the picture. Or there's one about a gas station when they're like, I put the pump into my car and I filled up my gas and then I was able to drive, but even though I didn't see the gas, I know it's in there, right? That doesn't matter. And then there's one she uses about bikes and something about crossing a border with a bike and not knowing the bike is stolen. My point is that doesn't matter. My point is that is to cloud what we're really here for, right? And so 8 seconds that he had opportunity to pull a gun and did. And that matters because Brown had less than 2 and it was pulled.
So the law of credibility is on page 3, it's paragraph 1. And so this is how you use these factors to determine your human lie detector test abilities. So you're looking at their manner of testifying, their opportunity of knowing the facts, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. So one of our questions in jury selection is who here felt that they had good instincts of determining credibility? Because each witness, you have to determine whether or not you believe them in part, you don't believe them in all, you believe a piece of what they say. That's what you get to decide. You get to listen to that evidence and you determine the facts. So let's go through the testimony. We had Detective Baker. Now, one thing important that Detective Baker testified was that the first 911 call was at 11:02 p.m. because this is a timeline case, right? 11:02 p.m. by Frank. Detective Baker also brought you in State's Exhibit 3, that is the surveillance. Within State's Exhibit 3, you should know that there's camera 1, which is the one with sound, camera 3, which is the other direction of the cash register that doesn't have sound, and camera 31 is the camera that gets the aisles, okay? Detective Baker testified that my client had opportunity to pull a firearm, but he didn't. That Alejandro Brown pulls a gun within seconds. And when I asked her about the body language of Jabari and Penny, she says, well, they look like they got caught off guard. That's important. She testified, and Detective Baker, and we'll get to that. But Detective Baker, this is law, page 3, paragraph 5, prior statement. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. Detective Baker testified that she spoke with me before, that she's answered my questions about this before, that she said before, under oath, that Alejandro Brown pulled first, shot. And then you could tell they tried to kind of clean it up, but she knows what she said. And that was her truth. Might not work with their theory, that was her truth. So, Detective Baker, she sets up the timeline. At 10:59:18, Airieon, Jabari, and Penny arrive. At 11:30, Airieon and friends walk inside the gas station. At 11:01:56, Alejandro Brown walks into the gas station. At 11:02:02, Airieon and friends are walking up the aisle, drinks still in hand. Brown approaches cashier and orders Newport shorts, money in his hand. At 11:02:05, Airieon passes his drink, prepared to defend himself and his friends, because that's another part of this.
There's no evidence that Jabari or Penny had guns. When Alejandro Brown saw my client, he pulled a firearm immediately. So in the event that my client didn't have a gun, then Jabari and Penny could have been hurt too, especially with a switch. Because what Ms. Van Holm testified to earlier is when you pull that trigger, multiple bullets come out at once. Bullets don't have a name on it. At 11:02:07, Airion's hand is in his left pocket. Brown's hand is on the gun grip on the right side, right rear waistband. That was when the state was trying to say he was pulling up his pants, but I want to get there. And 11:02:09, my client's hand is still in his pocket. And at that point, Alejandro Brown's gun is fully exposed. 11:02:09. At 11:02:10, Airion's retrieving his firearm. Brown's gun's fully exposed, positioning firearm to his left hand and shoots immediately. Jabari and Penny take cover. Both individuals switch hands. Both individuals are shot on their left side. Airien and his friends immediately head to the hospital. And so this is just stuff that came from Detective Brown. Now, Frank didn't really say much, so it's blank. But Frank is a great guy, okay? I mean, Frank's a great guy. He works his manager position. He's been there for 18 years. But he also said he didn't know anyone, and he didn't even feel it coming. He didn't even feel like, oh, there's animosity right here. Now, Dr. Geller, yes, it's never been in dispute this young man died. And I'm not here to say that he shouldn't have been driving with alcohol in his system, but I am here to say that for a .048, you're feeling something, right? And so at that point, I'm not saying he couldn't drive his car, but I am saying maybe if there wasn't alcohol in his system, maybe he wouldn't have been so quick to pull a gun. Mike West came and testified. He told you he searched my client's home. He found no illegal items at all and found 2 receipts for legal gun purchases. Detective Nelson, the lead detective in this case. Now, she said that she spoke to Jabari Johnson, that she got information from Jabari Johnson, but you didn't get to hear from Jabari Johnson. You got to hear from his mom after a warrant got put out for her. Ezekiel Allen, Danielle Bryant, and she admitted that the only exhibit that determines who pulled the firearm first is the surveillance video. And so 11:02:09 is very important in this case. Page 3, paragraph 4, impeachment. The credibility of a witness may be attacked by disproving the facts to which they testified. 11:02:09, that's the last question I asked her. Whether or not a gun was in Mr. Brown's hand at 11:02:09, she said no. I said nothing further then, because she lies, okay? So let's watch the video.
उसके पे आउट से बोलिया में कर दिया था बोलिया का मैंने दिया
Okay, and if you see, Mr. Brown is still shooting from the bottom, from the floor.
उसके पे आउट से बोलिया में कर दिया था बोलिया का मैंने दिया
Okay, and we'll go back to the video. I have more in this slide, but because the video is so important. But at 11:02:09,
उसके
clutched in his right hand, pulled, exposed. To say he didn't have a gun in his hand at 11:02:09 is a lie. That's just not true. I'm not saying that like I said, we don't get to make our files. But it's important to just tell the truth, okay? So then ADA Sprinkle. He is the individual that came in yesterday to talk about phone records of things that aren't in dispute. Terry Johnson came, Jabari's mom, and then expert witnesses. Now, this law is found on page 3, paragraph 2, and it says that the testimony has been given in this case by certain witnesses who are termed experts. The 2 witnesses that we had in this case that are experts are Dr. from the autopsy and Ms. Van Holm from GBI.
And Ms. Van Holm testified to you today that she had 10 .40 caliber bullets, she had 14 9mm bullets, and that little piece on the back of Alejandro's gun, it's just this little square, is an alteration that's illegal that causes a firearm to become an automatic weapon. So the problem is, so you're saying that, well, Alejandro Brown's actions were justified. Justified when doing something illegal? It's illegal to have that gun. My client's gun wasn't illegal. That's huge. And then she's like, intent before, during, and after. When he carries that gun, that's his intention. There's only one reason for a switch. Page 3, paragraph 6, a single witness. The testimony of a single witness, if believed, is sufficient to establish a fact. There's no legal requirement for corroboration. So you only have to believe one. And my client didn't need to testify. He chose to testify. I said, why? He said that y'all need to hear his truth, right? But you still get to evaluate him as any other witness. But what did he say? He said on 4/20/2019, he was at that gas station. He said he saw Alejandro Brown. He knew of him through Diamond. He had received Instagram FaceTime saying, I'm going to effing kill you. That he passed off his drink. And he did not immediately pull his firearm. I said, why didn't you pull your firearm? He said, this is stupid. Because this is stupid. But if he had not, he would be dead. And Alejandro Brown's actions show that. He said he took the gun off the floor so that he couldn't be shot again. That after the gas station, they went straight to the hospital because he was shot 4 times. That his lawyer had advised him to, his previous lawyer had advised him to turn himself in. That he since then has been required to have no contact with Jabari Johnson. And lawfulness character trait. And this is important because you're going to get law on this. So he's a legal gun owner, no arrest prior and no post-arrest. So then there's like, well, what about that time that that they said that it was self-defense? Well, first of all, never shot, never arrested. So when he's like, I've never been in this situation before. Well, the problem with that is the lawfulness character trait is in his favor, right? And so the issue with trying to attack him for that is that, what, are you going to use the fact that he's from Southwest Atlanta and that's where he's grown up his whole life? That's where shootings occur in this county? That's not fair. He told you that he had no intent or motive to kill or to rob. He told you that they went there for drinks and they wish he never did. They weren't even really going to the store initially. So page 3, paragraph 11 is about good character. Evidence of the defendant's character trait of lawfulness, if any, has been presented to show that he acted consistently with that character trait in this case. You should consider character evidence, if any, along with all the other evidence in deciding whether you have a reasonable doubt of the defendant's guilt. That's the law. And the fact that he's a 27-year-old young man, this happened 5.5 years ago, he'd never been in trouble before, and he hasn't been in trouble since. Because he's not just some dumb kid out doing shootings. He had an opportunity to pull a firearm immediately and chose not to. Chose to make sure it was necessary first. Page 3, paragraph 9, prior difficulties between parties. Evidence of prior difficulties, or lack thereof, between the defendant and the alleged victim has been admitted for the sole purpose of illustrating the state of feeling between my client and Mr. Brown, or the reasonableness of any alleged fears by the defendant. So The state's arguing that this happened because of the Instagram call. My client's testimony was that he prepared because he'd been threatened before. This isn't an act of revenge. If it was revenge, he had opportunity to get revenge. That's not what happened here. The purpose of understanding about prior difficulties is to just understand where he was coming from in the moment. That's it. Page 1, paragraph 4. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. And that's the law, and it's right in the front. So another thing about the law, and the reason I was giving page numbers and paragraphs, is that the law there isn't titles. It's just straight paragraphs. And so you won't see the word proof beyond a reasonable doubt, but that's why I provided the paragraph numbers. So what is a reasonable doubt? Page 1, paragraph 7, a doubt of a fair-minded, impartial juror honestly seeking the truth. A doubt based upon common sense and reason. Wavering, unsettled, or unsatisfied is a doubt of the law, and you must acquit the defendant. So let's talk about what an affirmative defense is. This is page 6, paragraph 3. My client has raised the defense that even if he committed the act described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. Something. They didn't provide anything on rebuttal. So page 6, paragraph 5 talks about justification for defense of self and others. Jabari and Penny. A defendant is justified in using force that is intended to or likely to cause death or serious bodily harm when, 1, he reasonably believes that the use of such force is necessary. If he had not pulled a gun, because he doesn't pull it out initially, if he had not pulled a gun, he would be 745. To prevent, 1, death or serious bodily injury to himself or a third person, Penny or Jabari, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another. So what does that mean? So you can use a gun in a justified manner when someone's about to commit aggravated assault on you. Okay, so if my client had just pulled a gun right from as soon as he passed his drink, pulled a gun and shot him, no, that's not justified. But he waited until the other guy pulled a gun. So to prevent the forcible felony of aggravated assault on him and his friends, to prevent that, he closed a firearm. That is justification. The state has the burden of proving beyond a reasonable doubt that his actions were not justified. They have to go that extra step. If you decide that his actions were justified, then it's your duty to find him not guilty. And no reasonable belief. This is page 6, paragraph 9. For the defendant's use of force to be justified, 1, the defendant must believe that this use of force is necessary. So 1, it has to be necessary. 2, the belief must be reasonable, a reasonable person. 3, the defendant's reasonable belief must be what prompts him to use force. Remember, the justification doesn't come until 11:02:09. Like that's when the guy pulls a firearm. That's when justification starts. Like I said, if he had pulled a gun right when he saw him, that wouldn't be justified. But we're not arguing about that. That whole time is just opportunity that he could have, but instead he showed you his heart, he showed you his intentions by not. Page 7, paragraph 1 is about justification. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone, if the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life or another's life is in imminent danger. So this says on page 7, paragraph 1, a menacing action. Pulling a gun out is a menacing action. That's what this is about. Not only did he pulled out and immediately pulled the trigger. The state already talked to you about no duty to retreat. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. So then first of all, I submit that I do not believe my client is the aggressor, right? That's where we are. But no duty to retreat. So the state's like, well, why didn't he run down the aisle? Who's to say he wouldn't have been shot in the back? Or why didn't he run out the door? If you actually look at my client when he was looking out the door and he pulled his pants up, you might think he was thinking about it. Passing his drink off first. But you just have to look at the video because ultimately you guys determine what the facts are, right? So I'm starting the video at 11:02:01. Now, this portion of the video is only 2 seconds because this is the portion of when my client actually sees Mr. Brown. That's the first 2 seconds. No provocation. There's no provocation there. So then they're like, well, he provoked it. It's not provocation. So now here is the next 6 seconds. This is when my client pulls out his drink and has 6 seconds before any guns are pulled and chooses not to. And not only does he have 6 seconds, he has this entire space. And the body language of Penny and Jabari, you can tell, just like Detective Baker said, that they were caught off guard, that they didn't even see it coming. 6 seconds that he did not pull a gun. Could have, but didn't. As soon as Alejandro Brown turns around, he immediately grabs his firearm. So Alejandro Brown is looking out the window at 2:08. Turns. Oh, that's 06, 2:06. Alejandro Brown's looking out the window at 2:06. He turns at 2:07. Watch his right hand. And he immediately pulls a firearm. He immediately pulls. Body language. So I said this in opening. I asked that you just look at everybody's body language involved. The last portion of the video is the 6 seconds. And if you see, he's still shooting from the ground. But once he stops shooting, my client stops too. That's not excessive force. This is terrible and traumatizing, but that's not excessive force. And he's not the aggressor. So I took this is the video from the other direction, just because we're not trying to hide any balls. You guys determine the facts. This video is 8 seconds. There's no sound. But it confirms where his right hand was. And it confirms that he switches hands to the hand he actually shoots with. It shows his intentions. They say before, during, and after. My client's intentions don't indicate provocation, aggression. During, it indicates necessity. And after, it's not excessive force because he stops. So the state used this picture. This is from 11:02:09. I want to just hit each little screenshot for this 1 second, okay? Because I want you to watch my client's hand because it never comes from the pocket. 11:02:09, 1, 2, 3. And you know for sure that's in order because you see the way Penny's walking. Penny's the gentleman in white with the squares. 1, 2, 3. My client's hands never left his pocket. Alejandro Brown's already gripping his firearm with his right hand. We already talked about circumstantial evidence, but just so you know, it's found on page 2, paragraph 7. So it's not that they must, to authorize a conviction on circumstantial evidence, the proven facts must not only be consistent with their theory of guilt, but must also exclude every other reasonable theory other than the guilt of my client. So this doesn't work. So let's talk about it. Now, there's always two sides to the law, right? And the law is rarely in any of my clients' favors, but the law here is justification, defense of self or others. So the state's going to come up here and say that a defendant is not justified in threatening or using force if he is the initial aggressor. That's page 6, paragraph 8. And they get that from this. In those 6 seconds, he is not an initial aggressor. And then they wanted to get him, they were attacking him when he was on the stand about, well, you were talking whatever behind his back to make him come out. My client doesn't say anything until the shooting starts. Justification of self or others, page 6, paragraph 8. The state's going to say that a defendant is not justified in threatening or using force if he provokes the threat or use of force against him, provokes it. Preparation and provocation are two different things. The law, page 7, paragraph 2. Words alone never justify the use of deadly force, no matter how abusing or provoking. So meaning, if I call you out the name, every word in the book, that's not enough for you to just shoot me. That's what the law is. But verbal threats accompanied by some menacing actions can justify use of deadly force. That's the law, page 7, paragraph 2. These were the 3 pictures of showing who grabs a firearm first. Oh, I'm gonna play them again, but 0209. This was the picture that Ms. Russell was saying that my client was already clutching his gun. But if you watch, his hand never leaves the pocket. Alejandro Brown already has his gun fully exposed. And this is just the other side of that, because remember the video, the time isn't off. So this is just the other side. It goes from this is 10 seconds and then he pulls forward. So we're not trying to hide any balls, but this is a very quick situation. We did a moment of silence for the 8 seconds, right? But this is a very quick situation. And in the split second that Alejandro Brown, his first instinct was to pull out his illegal gun. And then they're like, revenge. A defendant is not justified in threatening or using force against another solely for revenge. This isn't revenge. If it was revenge, my client could have been shot, not giving him a chance to shoot him 4 times. This is necessity. So the law is that after my client raises the defense, an affirmative defense that he was justified, that the state has to disprove it with facts, with evidence. And it just hasn't happened here. This is about the right not to die. He didn't immediately pull a gun. But if he had not pulled his gun out, by the time Alejandro Brown saw him, he would have been shot. Penny, Jabari, they would have been shot. Ladies and gentlemen, I'm asking that when you go in the back and deliberate, that you go through the evidence, that you watch that video, slow it down, make it bright, sharpen it, because my client is not guilty for malice murder. There's no evidence that he has malice. There is none. He did what we want people to do. He thought through the process before he just pulled a gun. Count 2, felony murder. So to get to felony murder, you have to go through aggravated assault.
If my client wanted to commit aggravated assault, he could have. He had the opportunity to, but he didn't. Alejandro Brown could have moved and gone on without his way, just like the state says my client could have. And if, just like my client said, I said, why didn't you pull your gun? He said, because this is stupid. This is stupid. This is stupid. But for him, it was necessary. An armed robbery? I mean, that's throwing the kitchen sink. I mean, armed robbery, like, where, when, right? So, I mean, what's the indictment say? Oh, and you know, when we initially came in and then we're like, who in here already has an opinion of guilt or innocence? When you hear these words, armed robbery, you're like, whoa. This makes me feel a type of way. Remember, feelings, that's not what matters here, but that's not right. So armed robbery, count 3. On the 20th day of April 2019, did unlawfully with the intent to commit theft. He told you, I just didn't want to be shot with him. Take a handgun, the property of Alejandro Brown, the illegal handgun, from the person and immediate presence of Alejandro Brown. Okay, well, Alejandro Brown was already out of the store, so we didn't take it from him. By use of a handgun, so that's like really sticking somebody up, like, give me what you got. That's not right. This isn't. And then possession of a firearm during commission of a felony, but that charge is for all the other ones. So count 3, armed robbery, we're requesting a verdict of not guilty because he deserves it. Count 4, aggravated assault. This goes to count 2. And count 5, possession of a firearm during commission of a felony. Now, I didn't use too much of your time, and I appreciate that everybody's been listening and taking notes because this is important. And I mean, just you being here, your civic duty here is so important, and we appreciate you. Just caution, when she comes up here and she goes, Miss Bacon, it's not about me, okay? When you see analogies and see pictures, it's not about pictures, right? We're not here to sway your feelings, but you're supposed to separate feelings, right? We're just here to put the evidence out before you to let you determine the facts and apply it to the law. But I'm asking that you acquit that. Thank you.
All right. Does anyone from the jury need a quick break before we resume? All right, let's take 5 then. Whenever they're ready, let's bring them back in.
Here, oh. Good. Redacted one?
Yeah.
Do you want us to sign it?
Trying to show it to you.
No, they don't care.
All right, I'm gonna do this. Or actually, we can just.
Is this old? Oh, this one.
I hear anybody clap?
Yeah, the boy, I just.
I didn't hear
The
it.
boy with the gray shirt on and the low hair.
I didn't hear
That's
nothing,
what
but
she, that's what she got in for, when she kept short report with one in the video, he was clapping.
how loud, what he was
It
doing?
wasn't, it be like, of course, we right here in front of them, so we could hear it. But every time she rewinded and showed it back, he's clapping. What the fuck is he clapping?
How he was clapping? I mean,
You didn't hear it? I mean, I can't hear
I
it.
didn't
I
hear that.
don't. You don't hear anything, do you? That's what just pissed her off. That's why, cause she know, you as you can see, she normally don't even say nothing. But,
a lot of people don't say nothing, but when they do an outburst, when people get upset and they go from 0 to 100,
and I get
it
it.
happens.
I get it,
Yeah.
and I get that, but then that's why, I don't know if you heard me, and I was like, why she keep doing it, cause it's not a laughing matter, that's why. If we gotta, cause they gotta take it in the back and look at it, if that be the case, if you got a plan, I think it's because.
I'm gonna be honest with you, I'm gonna address everybody in the judgment goes well.
Yeah,
It's zero tolerance, we're not just gonna tolerate it. on
and
both
I
sides.
mean, her not coming back, it's cool, it's not a problem
The
with that,
reason
but
why
I
she's, the
understand
reason why
why
she's not coming back, because when I asked her not to do it, I said, ma'am, you can't not
Oh,
have outbursts in the courtroom. But she went back and forth with me about justifying him and then not listening to me and.
That's his best, she his best friend, so that's, you gotta do your job. Again, you gotta do it.
She's,
You said what?
I'm gonna be honest with you.
You gotta do your job. Your job is your job. It is what it is. I was just saying that to say that was probably, yeah, but anyway, but that's what the outburst was.
I mean, I didn't even hear him. I mean, I heard her. That's what I'm
Yeah,
saying.
cause she had.
And not only that, she disturbed it. When you leave out of here, you disturb the court. When you get up and
Well, I
you,
didn't even hear you
and
and
you
her
disturb
going
the
back and
court,
forth.
and then you leave out of here, I ain't gonna say, like, really.
All right,
enough
they
to where
started
you
getting
disturb
tense now.
Yeah, I mean, I didn't hear that, I didn't hear y'all argument, so that's what I'm saying, like, but I get it.
That's all I was trying to address her, cause I heard her say
You
something.
gotta do your job.
And she said, nah, then she left out disturbing the court while she was getting up. She was disturbing the court. So I'm trying to tell her not to disturb the court. Now, if you do that again, you won't be allowed back in the court. So you didn't hear him clapping? I said, no, I didn't hear him clap. Then she went back and forth. That's why, you know what I mean? She went back and forth with me, pretty much telling me what I'm doing versus what I'm trying to advise her not to do.
When
And
it
she
fell anyway.
told me, so I just told her not to come back in the
That's his
court,
rule.
because that tells me she's not gonna listen.
I get it. You gotta do your job. You gotta do your job. I think it's just better when they.
Oh, you really?
It's gonna be a lot of things gonna set. A lot of
Yeah,
people in.
yeah.
That's why I'm telling them not to do it.
Yeah, no, I get it, I definitely get it. Let me use the restroom, but I.
You good
gotta
now?
do your job.
For now.
I'm straight. It should be all right.
Oh.
Doesn't have to be all right.
He gave us a time, you know.
Went the last time.
When they get ready.
Anything?
What'd you say?
The last round, they get interviews.
Mm-hmm.
I don't understand. They let them know.
Really?
I'll be real.
Hmm.
So they don't even know. Sitting like that. Yeah,
Yeah.
once she finishes, then they'll start.
I know, at the end, yeah.
Hang on. How long you gonna go? So, I'm gonna talk to tomorrow.
I told the gentleman that she said was clapping. I told him he can't come back. All right. Oh, man. Oh, man.
What you're saying, you wanted to see if the videos we play? We got it play.
VLC?
Yeah.
Yeah. You got the VLC. Which case are you serving subpoenas on? Mine? No?
Man, I got some things to say. So we got, I just want to see this case. What's the
Okay.
name?
Billy Wells? State v. Billy Wells.
Powell Smith. Did the Missouri Williams? did that
It's
for you?
not next week, it's the week after next.
Right, I think it's first up next week. Did you? I did. I did. It's okay, man. It's all right. Things you can't control, so that's all good. I'm starting, actually. It's perfect. I'm starting. Call come to order, remain seated.
Okay. Ready, Ms. Smith? Let's just go back on the record for 2 points. I was handed a copy of the redacted indictment by the state, so I've marked that as Court's Exhibit 3, just so we can have that as part of the record, and we'll include that as on the list of exhibits, the verdict form, and the charge. And then we've provided Ms. Fagan with our laptop that should have Wi-Fi and all other programs pretty much restricted to view the video. Do you think you've had enough time to take a look at it, or?
Yes, I just wanted to see their abilities, their abilities to change the video.
And are you satisfied?
They have them.
Okay. And so any concerns about sending this laptop back with a charger and that USB?
No.
Okay. Ms. Russell, do you want to take a look at it at all?
No, I mean, I've seen this, we've done this before in different trials, so it's fine.
Okay. All right. Then that's what we'll plan to do. Deputy Scott, can you check on our jury? Put it with the stack. Or wherever the stack of evidence is, I don't know.
In the box.
Yeah. Put it in the box, yeah. Mhm.
Am I great? It's like this. Yeah. Sitting there.
I think they removed the flickering ones. But they could go again at any point.
All right, for the jury.
Was
Here's the present judge.
Thank you, Deputy Scott. Ms. Russell.
This is stupid. This ain't stupid. Somebody died. Alejandro Brown died. This is stupid. What? That's what he thought about this? This is stupid? This ain't stupid. He was 25 years old. Somebody died. If it was so stupid, you would have walked out the door. If it was so stupid over Diamond, you would have turned your back and gone the other way. It wasn't stupid then. This is stupid. This is not stupid, ladies and gentlemen. This is about somebody's life that was taken away. Taken away. And that's what you have to say when you get on the stand, that this is stupid? Not at all. I am going to absolutely use analogies. Analogies help explain the law. I'm not trying to pull on feelings here. I want you to understand it. Because it's hard, it's difficult. You go back there and you read it and look at it, it's difficult. We've done the schooling, right? And it's still hard for us. So for a jury to understand that, I'm absolutely going to use analogies, and the defense does not want you to learn any analogies because she wants you to be confused. Absolutely confused about the law. Read it when you go back there. Read it. But the analogies work. And it's, again, not to pull on any sympathy, or on heartstrings. I don't even understand how that makes sense. But it's to explain things. She said analogies don't matter. They do matter. So here's my first analogy. My red light. Okay. So I'm going to tell you about a man who was on this bike. And when he was on his bike, he was crossing the border, okay? And he had a basket in his bike, in front of his bike. And as he was crossing the border, he stopped, okay, by the Border Patrol agent. And Border Patrol agent said, "Hey man, what you got in this basket here? What's going on?" And the man would say, "No, nothing, it's just sand. I'm just bringing sand over the border." And the Border Patrol agent was like, "Okay, let him go." And the man came back the next day, and the day after that, and the day after that. And every day the Border Patrol agent would stop him and say, "Man, what you got? What's going on with the sand in this basket? What is going on? I want to know, what is this sand in the basket about?" Right? And the man on the bike would say, "It's nothing. It's just sand in the basket." So the man would let him go through, just sand in the basket. And so at some point in time, this Border Patrol agent, he was ultimately up for retirement. Okay? And the man would drive the bike over the border, went to the retirement party. And at the retirement party, the Border Patrol agent said, "Okay, you came over the border every single day. You always had sand in your basket. Tell me, what is this about?" Okay? And he said, nah, I'm not gonna tell you. and kept focusing on the sand. And the Border Patrol agent got a couple drinks in, was in a chocolate party. And you know what? The man was about to say, I'll tell you later. Goes, all right, more drinks in the system. And asked him again about the sentence. And so the man eventually said, all right, I'll tell you what was going on, since you're retired now. So the Border Patrol agent listened closely. And the man said, you know, every day I would come here with sand in my basket. And you were so focused on the sand in my basket that you did not realize that I was smuggling over a new bike every single day I came over. Your focus was on the sand in the basket. Your focus was never on anything. What is defense counsel trying to do? She's trying to make you focus on the sand in the basket, the things that don't necessarily matter. The sand in the basket. Instead of focusing on what is at hand. All right, sand. So what's the sand, right? Defense motive. She says the motive, right, is because the motive for this entire thing is that Alejandro Brown wanted to kill the defendant. That's sand in the basket. Well, that does not make sense, right? Sand in the basket. Self-defense entirely is sand. Okay? Defendant hasn't gotten in any trouble after turning himself in. What does that matter? How does that matter to the case at hand? That is sand in the basket. Let me throw that out there that, you know what? He hasn't gotten in any trouble. Sand. Okay? How many times the victim was shot, right? In self-defense. So he was shot 4 times. That's sand in the basket. The switch. Let's focus on the switch here. Ladies and gentlemen, this defendant approached Alejandro Brown. He was the aggressor to Alejandro Brown. Alejandro Brown had every right to defend himself. So what does it matter that he had a switch on him? She's trying to say, oh, well, it was illegal. Well, he wouldn't have used it if the defendant wouldn't have come to him, wouldn't have been the aggressor. It doesn't matter, right, that he had a gun. He was using the gun in self-defense. Alejandro Brown was using the gun in self-defense. Oh, too many witnesses. The state's wasting your time. Then they said we didn't have enough witnesses. You didn't hear from this person. And then they said, oh, you know what? All that matters, right? All that matters is the video. So then why are you talking about how many witnesses and who was called? If you believe, right? If you believe that's all about the video, that's sand in the basket. Again, getting you to believe or try to think that too many witnesses or too little witnesses matters for their case, right? Oh, he turned himself in. Who cares if he turned himself in? Of course he turned himself in. After his face was plastered over the news, he didn't turn himself in before then, right? Sand in the basket. Oh, he turned himself in. What does that show? Again, cell phone records. Oh, those cell phone records don't show you anything. Well, ladies and gentlemen of the jury, you're going to get that indictment, and we have to prove every element in that indictment. That includes making sure that this defendant was the one, right? That this defendant was the one that shot Alejandro Brown. We have to prove that. Think about it. The state can put up their case, and the defense doesn't have to put up a shred of evidence. The defendant didn't have to get on the stand. They don't have to say a word. Not a word. But the state still has to prove that that was Airieon Young in that video. Whether or not he gets on the stand or not. Whether or not in opening statement she agrees that's him. That's sand in the basket by getting you to try to say cell phone records don't mean anything. And we'll talk a little bit more about the cell phone records later. Sand in the basket, Detective Baker's review, right? We want you to rely on what your view was. Not only that, sand in the basket, these screenshots that she tried to put in. She put in what, 10 screenshots? And then tried to say, oh, wait. The video is what matters. But when I went to Detective Baker and I asked her, look at these 2 screenshots. They say the same time, right? And they're different pictures, right? He's the one who put the screenshots in. Trying to confuse you. Sand in the basket. If what matters is the video, show the video and not rely on the screenshots. But again, when you rely on the screenshots like the defense has done, it shows something and you can manipulate what they want. Watch the video. From the very get-go, I said in opening, they both pulled out the gun seemingly at the same time. It's a hard call. Who pulled out the gun? So what you all have to decide is who was the aggressor in this particular situation? Who was the aggressor? Who initiated this? And the only person who was the aggressor and who initiated this was Airieon Young. Plain and simple. Plain and simple. I submit to you, even if you find out that Alejandro, or even if you think that Alejandro pulled out the gun first, he had the right to. He had the right to defend himself. Because, ladies and gentlemen, which you'll see others saying, she wants you to stick to 110209 or something like that. I have it written down. She wants you to look at that. That particular frame. Right? That particular frame, when I was up here with Detective Baker, when we showed that with Detective Baker, shows the defendant with his hand on the gun, and you could see the butt of the gun. You could see how his fingers are situated. He had his hand on the gun prior to Alejandro Brown even turning around. But the screenshots, remember, she wants you to look at the screenshots. They want you to focus on those screenshots. Sand in the basket. Focus on something, right, that has nothing to do with the case at hand, that video. Talking about 2 sides of the neck, right? How? How does that happen? Let's look at screenshots. Wait. No. Let's look at the video. No. Sand in the basket. Oh, I want to go back, right? Talk about lawfulness. Defendant's gun. Oh, I don't know what happened to my gun. They didn't report it stolen. You didn't say it was lost, right? Excuse me. You didn't do that, right? But I've been so lawful. I haven't done anything wrong. You had a gun. You stole a gun from somebody. You committed a theft and you did not find these guns. Oh, I'm going to be so lawful, right? But I'm not going to say anything about it, right? Client's gun isn't illegal. Well, we will never know. We will never know. How convenient. How convenient that you get on the stand and say, oops, I don't know where the guns are now. Sand in the basket. The 2017 incident, he was on the stand, he said he shot, right? Let's talk about this 2017 incident, okay? This defendant, right, said that he was, his first on direct, right? His first phrase was, I was so scared. I ain't never been in a situation like this before. He lied. Talk about credibility. He lied. And when I confronted him with that, you all took a break. We came back. I asked him again. I said, let's talk about that 2017 incident. Let's talk about it, right? You have been in a situation like this one before, correct? And he said, yes, sir. Yes, he has. So he lied to you. But they want you to say, "Ah, that doesn't, you know what, that doesn't mean anything. It means a lot. You know why it means a lot? Because he's been in a situation where he's had to defend himself before, and you know what? He stayed on the scene. He told you he stayed on the scene. He gave you his correct name. He gave all of the information. He talked to the police. And he told you that he was justified in that particular situation. And then got on the stand and lied to you. Lied. That he wasn't, that he had never been in a situation like this before. Well, ladies and gentlemen, I submit to you right there shows you his intention in this particular case. His intention was to conceal. His intention was to hide. But you know what he couldn't hide from? He couldn't hide from those high definition cameras. He couldn't hide from that. And so when his face is plastered all over the news, even though he's given a fake name, he ran from the hospital, his safe place, right? When he's already tried to conceal himself and he's plastered all over the news, he got rid of the guns. Now, now it's no longer I'm gonna conceal my identity, right? It's it's self-defense. Let me now say it's self-defense. No, not at all. This was not self-defense. So when they tried to say he didn't even shoot, you heard him right here. Heard him right here say he shot in that incident. So yes, it's important. Yes, that 2017 incident is important because it shows that he lied. He's been in this situation before, and he did exactly opposite of what he did in this particular situation with Alejandro Brown. Okay, she says, oh, and the victim was shooting on the floor. Well, the defendant was shooting at him too. What? And then let's go back. We said, oh, this was a switch, right? A switch goes, and she did a sound with Sarah Van Home, okay? Instead of boom, 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 it goes boom, 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 boom. Well, if that was the case, if it was in good working order, if this is a switch, which we'll never know, right? Because we don't have the gun, right? If that was the case, by the time Alejandro Brown fell on the ground, he wouldn't be able to shoot anymore. But again, we don't have that piece of evidence because of this defendant. How convenient. How convenient. State is arguing this happened because of Instagram call. I'm not arguing that it happened. I don't think it happened at all. I don't think an Instagram call happened at all. I think that's a story that was made up on the stand. But this is what the defense counsel came up and said to you. Sand in the basket. Oh, they arguing it was over an Instagram call, that this is revenge. No. What I said is if you believe there was ever an Instagram call, which we don't have any information, we don't have any records about Instagram calls, nothing, right? If you believe that, if you think that's reasonable, which I submit to you is not, revenge, he can, if he's saying that, he can't use justification because of those threatening calls, which again, there's no proof of. State then provide a rebuttal. You don't need a rebuttal. You don't have to, I don't have to put up a rebuttal. Want to know why? Because he lied. I can't, you can't prove a lie. You can't do that. This is the first time he gets on the stand and he says, whatever, right? So having a rebuttal, what do I put up if it's not there? They didn't put up any evidence of it, but his testimony, which we know that he has lied. So his credibility is at issue. And if his credibility is at issue, then you, ladies and gentlemen, can disregard his entire testimony. Disregard the entire testimony. Justification begins at 11:02:09. Wrong. No, it starts before. before. Alejandro Brown was justified. Alejandro Brown was justified. It doesn't start at 11:02:09. No. Way before 11:02:09, way before the shooting happened, this defendant had his hands in his pocket, pulling out that gun. And we'll watch it. Sand in the basket. The defendant told you he turned his back. Right? He told you he turned his back, but he was scared. And I think counsel said something about, if he would have ran down the aisle, right? If he would have ran down that, he would have been shot in the back. But he got on the stand and told you, yeah, I turned my back. It was on video. Yeah, I turned my back. So how are you scared? You're not scared. You're not afraid for your life. You turn your back on the person that you're supposedly afraid of. No, he had the upper hand on Alejandro Brown. So it was confusing. 6 seconds and 8 seconds. Watch the video. Watch the video. You will be able to watch the video, slow it down. You will be able to look at the video. You will be able to speed it up. Look at different angles. Please. Please watch it. Whether it's 6 seconds, 8 seconds, no matter what we do know, what's undisputed, right? And what the defendant got on the stand and said is, Alejandro Brown did not see him when Alejandro Brown walked in the door. Only person that saw him, Alejandro Brown, was this defendant. My client doesn't say anything before the shooting starts. We'll get to the video. Just a lie. Sand in the basket. Just to throw it out there. Just to distract. Don't take our word on it. Let's watch the video. All right, let's talk about the defendant's testimony. Diamond. We talked to Diamond. This shooting happened because of Diamond, right? What's Diamond's name? I don't know. We only talked for 3 weeks. It was a 3-week fling. A 3-week fling? Alejandro Brown wants to kill over a 3-week fling that he had with Diamond, no name, no last name. Again, summer of 2018 threats. Where are they? Where are they? Where's the record of it? Where is it? It's on trial for murder, ladies and gentlemen. You find the records. You find the records. I submit to you there are no records. I submit to you there are no records because it never happened. You got on the stand and you told them. So adrenaline was so high from threats of 8 months ago, I'm gonna pass my drink. He said that his adrenaline was high because of something that happened 8 months ago. And then in his testimony, he also said that he had seen in passing Alejandro Brown. Ain't nothing going on then. Saw him in passing, right? But 8 months ago or so, adrenaline still high. I'm gonna make sure I'm gonna pass my drink. I'm gonna turn my back on somebody I'm afraid of. I'm gonna feel for my gun. I'm gonna put my hands in my gun. I'm gonna make sure my gun is ready. I'm gonna pull out my gun. And I submit to you, he pulled out that gun. You can see it. You can see the butt of the gun. It's hard because it's a black gun on black pants, right? But he pulled that gun out. What else was Alejandro Brown supposed to do in that moment but to defend himself? What else? He said the hospital was a safe place for him. A safe place. That's what he says. This hospital was safe.
Objection, misstatement of facts.
Members of the jury, you'll remember the evidence that was presented during this trial. You should base your verdict only on that evidence. Ms. Russell.
Hospital was a safe place. I asked him that question. I said, this was a safe place. He agreed that was a safe place for him. He agreed. He said, but you know what? I didn't wanna, because I thought maybe, you know, Alejandro around, he was on the ground, right? With his pants below his legs, bleeding from gunshot wounds. Come up there. Come up there. What? He took his gun. He was on the ground, bleeding to death. What? Doesn't make sense. Then he talked about in his testimony, the gun, right? Taking the gun out, taking the safety off, which made no sense. He had his hand, if you see it on the video, left hand on his gun, set the gun, the safety, right? He actually didn't even just say which one, right? He took the safety off with. Didn't say. Passed it over to his right hand. And you saw how quick it was. You saw how quick that exchange was. From left to right. When you have time to take off the safety. And then again, the gun's left in the car. This is his testimony, right? Talked about the 2017 shooting already. Once confirmed, he shot. In that instance, someone was killed. He stayed on scene. He gave his proper information. He said it. He told you that. He was clear. Not this time. Not this time. He had a self-defense case previously. He knew what to do and he didn't do it. Okay. So what doesn't make sense, right? What doesn't make sense? And we've talked a lot about some of these already, so I'm gonna skip over it and then keep going, right? Right? Give, drink, you spend about a minute and 15 seconds picking out to your buddy, right? You just pass it over. No, that was intentional. That was intentional because he saw Alejandro around, right? Victim says nothing to him at all, right? And then on the stand, he says, I was trying to hide. He said that. He said he was trying to hide. I was trying to hide. Hide? You didn't try to hide. No time do you see in that video this defendant trying to hide. Talked about a lot of these. He says, I don't want no problems. I don't want no problems, is what he said. With his hand on his gun. No. Okay. Never calls the police. Doesn't make sense. And leaves the scene in a hurry. Okay. The truth is never changing, but the lie is always evolving. Always evolving. And that, ladies and gentlemen, his testimony, always evolving. He had 5.5 years. Sorry it took that long. 5.5 years. Okay, all right. So no matter how long he sat and thought about these, facts don't change. Okay. I want to show you this video just so you have another chance to watch. Okay, side by side.
You know, 229 and 299. Just down those people. देखो, ये कौन कर रहा है? साथ में क्या ना रहा है? हाँ सही सही कहूँगी बात। अभी इसमें 1000 डालना हो। 990 डालेंगे। 1000 डाल दे। No 1000 डाल। 20 कम होता। ये मेट्रो भी अभी है ना? हाँ आ गया आ गया। कुछ भाई हमारे को पूछ रहा है हमारे पूछ रहा मेरे को पूछ रहा ये तो इधर ही रहते
हमारे इन्वेस्टिगेशन हो रही है हम लोग क्या
उसको पूछना मेट्रो पीसीएस वाला
असल में क्या है काम में वीक क्या है वो दीदी मैनेजर वो है मनीष जी
हमारा गांड में उंगली रखना है अच्छा सीधा काम करना है तो एक बार छोड़ देंगे बनाओ करके इतना मेहनत कर रहे कौन करके पूरा उधर खेल लेके कर रहे हैं बाकी के स्टोर में
क्या करते हैं
बाकी के स्टोर में अच्छा नाटक करके काम कर रहे हैं 4 आदमी काम कर रहे हैं अबे 200 BCS में तो 229 है ना हाँ तो क्या करा उसमें ओवर आना बोल रहा तुम क्या कौन दिया उसमें
मुझे वो बुढ़िया का था और बुढ़िया नहीं वो नहीं जैसा कल्ला आता है वो बुढ़िया खेल रही थी पीछे तो वो इसका बुढ़िया का लगा 105 अब वो उसको 15 कल्ले को पहले दे दिया नहीं बुढ़ा बैठा नंबर नहीं बैठा गाड़ी पे नंबर 3 पे बैठा ये पर शॉप तो उसके पे आउट से बुढ़िया ने वसूल कर दिया तो बुढ़िया का मैंने दिया
Before, during, and after. All right? Before, during, and after. The defendant's intentions. Before, during, the aggressor. It shows that he was the aggressor. It's hard, again, it's hard to see who pulled first. Seemingly at the same time. Right? So malice murder, right? Aggressor said something to him, angry, shot multiple times, did not seek aid, did not seek help, and ran away. There we go. Aggressor. Shows you right there. Before, during, and after. Okay? Right. There's a charge about words alone. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing actions may justify the use of deadly force. In this case, Alejandro Brown was the one that was justified. Because the words of this defendant and his menacing actions. At no point did Alejandro Brown say anything, right? At no point did he turn around until this defendant was talking. This defendant had his hand on his gun. Again, Alejandro Brown was the only one defending himself. So again, what we have here, reaching for the gun, his menacing action, plus words, that's enough to convict him. That right there is enough, right? Pulling the gun and his words, that's enough to convict him. That is enough. You don't have to show who pulled first or that Alejandro Brown pulled first or Airieon. No, this right here is enough to convict. Watch it right here. Before, does not reach for the gun when walking up to the counter at all. It's in his pockets up here. You'll see. His pockets. Oop, spots. Alejandro Brown. Passing the drink before. Oop, Spot Alejandro Brown passed the drink. Look at Penny turning away. She talked about body language, right? There's no reason for us to believe that Penny, or excuse me, that's Jabari. Penny or Jabari knew anything about this, because it's what the defendant was doing. The body language of Penny and Jabari doesn't matter, right? It's the defendant is the one. Reaches for the gun multiple times in these spots. So let's count it ourselves. Okay.
So punch. Abo उसको पकड़ा कर ले पकड़ ले नहीं बुढ़ा
1,
मनी बैठा है गाड़ी पे.
2, 3, 4, 5. Still walking toward them. 6, 7, 8. Gun is out. I know Baker counted, I think 8 times he's doing it as he's looking at him. And the gun comes out before Alejandro Brown. Gun is out. Again, before you can see the butt of the gun, you can see it, right? So in this, you'll have a laptop in the back and you'll be able to go right up here to view or tools. I can't remember which one it is. But one of them allows you to use interactive zoom, okay? Zoom in. This is the interactive zoom feature. That's what I've done, all right? You will be able to look at the video and zoom in, slow it down. To slow it down, you use the brackets, slow it down, speed it up. The brackets, for the left bracket, that's to slow it. The right bracket is to speed it up, okay? Watch it. You can see the butt of the gun. This is when, this is at some point you'll see the time. But this is when the defendant is walking up. Brown. It's the gun right there. There's the gun. There's the gun. He has his hand on the gun. You see it. Before Alejandro Brown even sees him. The sound is off. So make sure you go back and listen to the sound. The sound is off because of the Zoom feature that we're sharing this on. But you see the gun. You see it multiple times. Someone said, no, he was just tapping. No, it was more than tapping. You can see the gun come out. You see him pulling it up. Okay. So this is at 23:02:03, all right? Gun comes out. You'll see that. And I just used the interactive zoom feature and zoomed it to the time. You just moved it over. Guns out. Gun was out. His intent was to kill. There's no self-defense here. His intent was to kill Alejandro Brown. And that is clear from his words and from his actions before, during, and after. So during, right? Victim turns around and sees 3 men behind him. And one has a gun. And one has said something to him. Right? Alejandro Brown has no other choice. All right, let's talk about the witnesses. All right, we'll zoom through this, okay? Witnesses, Farouk, Frank, he said he didn't know anything, what was happening. He was servicing Alejandro. Well, of course, he couldn't see what was going on back there. He was servicing Alejandro, okay? He worked at the incident location. Victim came to buy cigarettes. Victim wasn't out there, wasn't doing anything wrong. He was buying cigarettes. That's why we brought Frank here, okay? Next. Again, the after. Detective Baker comes. Again, defense wants you to rely on those screenshots to come to a conclusion that we showed you was debunked. Not her job to make that determination, is your job, all right? Terry Johnson. We have to prove it's Airieon Young. Remember, opening statements aren't evidence, okay? We still have to prove to you that's Airieon Young, and I know it may seem silly that we brought her here, right? But we still have to prove it. Yes, and then when you have a subpoena, you are to show up for your subpoena. She did ultimately show up. She wasn't arrested. She showed up. She walked in and she walked out. But yes, you show up because this is important. We want to make sure that we are proving the case to you. But of course, defense doesn't want that. Because in one hand, they talked about, oh, you didn't hear from this witness. But on the other hand, they say, well, they wanted to bring her in, right? But they wanted to arrest her. No, it's not that the state wanted to arrest her. You want her to do her duty, just like you are doing your duty right now. Follow the law. Again, we have to prove venue beyond a reasonable doubt, okay? Venue, ID, beyond a reasonable doubt. You have to prove that. Venue, that this happened in Fulton County. Detective Mike West, let me put his name here. He obtained a search warrant, collected 2 Taurus 9mm with receipt box in the defendant's name, okay? Oh, that's not important, she said. Why not? It showed that he had the opportunity to have the gun. Absolutely important for Detective Mike West to be here. Dr. Geller, 10 shots to the victim, manner of death is homicide. Again, we have to prove that he was killed, okay? And that he was shot, excuse me. All right. Detective Nelson, we've gone through a lot of this already, so I'm not gonna go through it, but her role is important. And at the end of it, she said the defendant was aggressor. It doesn't matter to her about a conviction or not. That at no time did you hear that on the stand. That's what the defense wants you to believe, right? It doesn't matter. She's still working, right? Unfortunately, because in Fulton County, Union City, you got to continue working, right? Mike Sprinkle, defense says it doesn't matter. Doesn't matter about his phone records. Yes, it does, because he tried to hide his identity. And it shows, the phone records show that he was there right before the incident, and he was there at Grady after. It shows his identity. It does matter. You are to seek the truth. Seek the truth, not any doubt. Sarah Van Holm, excuse me. 1040 from the victim, 14.9mm from the defendant. Projectiles from the body match a Taurus 9mm. Well, ding, 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 ding. What type of firearm did this defendant have? Taurus 9mm. Okay. She talked about a switch. Well, I wish we had the gun once again. All right. Concealment of the gun, we talked about that. We can move on. All right. Where the weapons, we talked about where the weapons. Oh, I want to stop at this. He says that he was scared that the victim was going to come back, That's why he placed the gun in his pocket. Okay, if you're scared, throw the gun, kick the gun, turn the gun in, right? That's what you do when you're scared. You don't take the gun with you. No, that was to conceal. The intent was to deprive the victim of the gun after he had already used deadly force against him. That was his intent. He wanted to conceal that gun and deprive him of it. He stole it and never returned it. Didn't even report it stolen or missing. A gun, this lawful person. We saw the armed robbery. Again, I'm not going to play the video. See, defendant comes, picks up the gun. You're more than welcome to watch the video as many times. Please do it. 230319. Some point you'll see the defendant come and pick up the gun. Okay. And he'll look outside, look around, see defendant, victim on the ground, come back inside and say, come on, come on. You'll see it. And you can hear that part. Okay. Oh, hood on the head. Again, concealing. Hood on the head wasn't there before. Now trying to hide. Again, concealment of the gun. See him come out, look, goes back inside and goes back into the car. You see all of that, okay? You can watch that video. I can play it. You're more than welcome to watch that video again. But it just shows his concealment. It shows that, okay? All right. Grady hospital records. Lying about who he was, right? It's right here. You get the records. And you get to look through them, okay? Patient left. This was a safe place, right? He left before the cleaning of the rooms was even done. Patient was a walk-up, multiple gunshot wound, state that he was in a convenience store when he heard shots and ran. He lied about what happened. Lied about what happened. You would think that if you were scared that somebody may come back up there to hurt you, you tell them, hey, you know what? Somebody just shot at me and I'm super scared. Can we please get some security in this hospital? Can we please make sure that nobody comes up into this room? Please. He didn't do that. He just lied. He lied to them because he was concealing it. Again, guilty conscious, but we're going to pass this part. All right. Guilty conscious, no emergency phone calls made. Only to Jessica Walker. Because Penny was his friend and had his code. It shows the intent to kill. Again, this is the video. You're more than welcome to watch it again. Please watch it again. All right. Again, I go through the ways the defendant's actions were not self-defense, right? Walks toward them, turns around, feels for the gun, passes off drink, feels for the gun. Okay. Extra slide, sorry. He is the aggressor. The ways that Brown was caught off guard, all right? Now, I kind of hit on this, but it's important. The only reason why now he's claiming self-defense is because of the cameras, right? We have a camera that shows him. Otherwise, he tried to conceal his identity. But now that we have a camera, you got to come up with another reason. Got to come up with another reason to, ooh, that doesn't look good that I'm actually caught on camera. Now let me say it's self-defense when that didn't happen before, okay? And all of those reasons, right? All of the reasons listed before show you and explain to you why he was trying to conceal, okay? Alejandro Brown did not deserve to die. No, not that night. Not that night. He did not deserve to die. He became number 745. Defense counsel talked about Southwest Atlanta. This is not a Southwest Atlanta issue. This is a Fulton County issue. Fulton County, this is our county. And at no time should this behavior be tolerated. No time. Whether it's Southwest Atlanta, Buckhead, Johns Creek, wherever. At no time should this be tolerated. This happened in Union City this time. But nowhere else should it happen. This defendant murdered Alejandro Brown. When Alejandro Brown just wanted to buy a pack of Newport shorts, that's it. He wasn't doing anything wrong. The defendant's intention was to kill him and to injure him. And it's shown through his actions before, during, and after. And ladies and gentlemen, enough is enough. This is not the Wild Wild West. I explained that to you before. This is Fulton County, and we do not allow that in this county. We should not allow that in this particular county. Enough is enough. Hold this defendant accountable. Hold him accountable for his actions. Hold him accountable for his actions because he knew what his intentions were. He knew that he was grabbing that gun. He knew he was going to injure Alejandro Brown. He was 25 years old, and he should not have died in this manner, on the cold ground, on the sidewalk with his pants below him and gunshots riddled in his body. Find the defendant guilty on each and every count of this indictment. Thank you.
Members of the jury, you are considering the case of the state of Georgia versus Airieon, Dominique Young. The grand jury has indicted the defendant with the offenses of murder, felony murder, armed robbery, aggravated assault, and possession of a firearm during the commission of a felony. You'll be provided a copy of the indictment and these charges during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. If that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch, and may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though the conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish the conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe and do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify, and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim, or the reasonableness of any alleged fears by the defendant. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. Evidence of the defendant's character trait of lawfulness, if any, has been presented to show that he acted consistently with that character trait in this case. You should consider character evidence, if any, along with all the other evidence in deciding whether you have a reasonable doubt as to the defendant's guilt. The defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances, or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. When a count of an indictment charges that the defendant committed a crime in more than one way, you may convict him if the evidence shows that the crime was committed in any one of the ways charged. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon is a felony, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant assaulted another person, and 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, within arm's reach of his person, and 3, while committing a felony that is a crime against or involving another person. Murder, felony murder, aggravated assault with a deadly weapon, and armed robbery, which I will define for you shortly, are felonies. The term firearm includes any handgun. For armed robbery, the state must prove that the defendant, 1, took another person's property, 2, directly from another person or from the immediate presence of another person, 3, by using an offensive weapon, and 4, with the intent to commit a theft. An offensive weapon is any object that is likely to cause, or actually does cause, death or serious bodily injury if used against someone. Immediate presence, as used in our armed robbery statute, is applicable even if the taking occurred out of the actual physical presence of the victim, if what was taken was under the victim's control or his responsibility, or if he was not too far distant. It is not required that the taking be from the actual contact of the body, but if it is from under personal protection, it will suffice. The defendant has raised a defense that even if he committed the acts described in this indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when 1, he reasonably believes that the use of such force is necessary, 2, to prevent death or serious bodily injury to himself or a third person, or to prevent the commission of a forcible felony, which means a felony that involves the use of force or violence against another. Aggravated assault is a felony. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if he provokes the threat or use of force against himself, intending to use that threat or force as an excuse to harm the other person, or is the initial aggressor, unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. For the defendant's threat or use of force to be justified, 1, the defendant must believe that his threat or use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary. And 3, the defendant's reasonable belief must be what prompts him to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant or another's life is in immediate danger, the defendant or another is in immediate danger of serious bodily injury, or a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force. A forcible felony is a felony that involves the use of force or violence against another. Aggravated assault is a forcible felony. A defendant is not justified in using excessive force while acting in self-defense or defense of others. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. A defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for the purpose of avenging a past wrong and not for the purpose of preventing an imminent use of unlawful force, death, serious bodily injury, or commission of a forcible felony, then you would be authorized to convict the defendant. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows, beyond a reasonable doubt, that it might have been committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did on or about April 20th, 2019, commit the offenses alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of an offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. We have prepared and will provide to you during your deliberations a verdict form, which you may use and you can fill out for each of these counts. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion about the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence according to the law given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. If you must decide this case for yourself, each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. To that point, we will provide you with a laptop and a copy of the state's exhibit, which is the surveillance video in this case. You are permitted to use that laptop and to do with what you want, if anything, with that exhibit. But I charge you that you are not to use this laptop for any other purpose. As I understand, Wi-Fi has been disabled in any other programs. Whatever your verdict is, it must be unanimous. That is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. In just a moment, I'll ask you to retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in this case. A note on timing. We do not have to break exactly at 5 o'clock. We'll allow you to get started, and you can give us direction as to if and when you want to break for the day. At some point, we will have to make that decision for you because the building shuts down. But we'll wait for direction from you. So, is there any objection to the charges given by the state?
No, Your Honor.
Any from the defense?
No objection.
All right. So, with the exception of jurors 37 and 38, if you two could wait behind with us, you may now retire to the jury room.
That means you good.
All right, jurors 37 and 38, you may have done the math and realized we had a few extra. We do that because, as I'd mentioned before, trials aren't scripted things, and sometimes we lose jurors and we need to sub people in to make sure we can get something across the finish line. So you are our alternate jurors. You're not off the hook yet. We'll allow you to go ahead and go home for the day, but there still might be a chance we have to sub one of you in should something happen during deliberations. We don't know how long that might take. So I'm going to charge you, you're still under the obligations of your oath, meaning don't do any research and don't communicate about this case with anyone at home or even amongst the two of you or anyone at all. And then we are going to give you a phone call once we let you know, hey, you got to come on back or you're excused completely. So if we don't see you again, thank you so much for your service. And please, for the purposes of tomorrow, I don't recall exactly where each of you live, but I'd ask that you be within an hour and a half of being here once we would give you that phone call. Is there going to be any issues with that? All right. Seeing none, thank you again so much. All right, Deputy Scott, as I understand it, the parties have already agreed to what exhibits are going back. Just for purposes of the record, I'm sorry?
I just wanted to check something in the exhibit.
All right, you feel free to check on that. And for purposes of the record, I would ask you to note, I don't know which way it's easier, either which ones are staying back or which ones are going in, probably whichever one's easier to detail.
Everything's going back.
Yeah.
All right, if all the exhibits are going back, then I don't know, there might be a point of putting some gloves in there too, since there's actually physical evidence, but I'll leave that to you and if the jurors ask for it. So if there are no objections about what's going back and we've got that all gathered,
Can I see the verdict?
it should be in there too. The form.
I'll pick it up.
You get those?
Yeah.
Throw them in the box. All right, there being no other issues or objections raised with what's going back to the jury, we'll just note their deliberations as beginning at approximately 4:40, and we'll see if we get some direction for them and check in around 5 to see what they want to do. So we'll be in recess.
You want a combo?
Ma'am, I'll tell you, you don't want.
Ready?
Not even.
I have like 1,000.
You know.
I like two big boxes of things. I really. I already had to walk
I'm
so
allergic
far.
to it.
The problem is,
Everybody should, they reward, they should give you a check.
hello.
I don't want your statue.
Hello.
But for what I heard, half of the checks bounced that they gave.
This is silly, but
No.
I'll put it on the record.
I don't.
All right, we're on 4, I believe. Court's Exhibit 4.
Yeah.
Okay. Yeah, I think so.
Question?
All right, you ready? All right, let's go back on the record. We've got a first for me. Anyhow, they want to sub out alternates. So the question or response written is jurors 37 and 38, who are our alternates, would like to be a part of the deliberation, comma. There are other jurors that would like to leave, be alternates. Can that be done? And then they wrote on here that the ones that want to be the alternates instead are 35 and 16. So I would be inclined to write back on here, no. But if the parties prefer 35 and 16 and both parties agree, I'm at least going to give you all the option. It's your case. So I don't know if you still have your notes of who's who, but I thought I would at least share that with you. And let me ask Deputy Scott, have our alternates already left for the day? Where are they exactly? So, okay. They're separate from the rest of the jury though? Okay.
I mean, it doesn't matter to me.
Which one?
I think you can, I think you're on the Jordan shirt.
That's right.
Back in the middle.
Oh, let me just inquire, did y'all, was this taken back up, the profile page that you had your notes on? Do y'all still have this? Because that was retrieved by Ms. Vortis. So you basically have no notes on who these folks are?
So we took, not on that, but. Just trying to remember.
I can bring them out if you'd like to look at them. If y'all are seriously entertaining this, it's really up to y'all.
Can I just say this? I think like, so what happens if they don't come up with a verdict today and let's say somebody gets sick tonight, then we don't have an alternate?
Those alternates, I'm still going to have them on call. I'm not excusing them. It's just that these two would instead go home and go about their lives and that sort of thing. So it's really just subbing the place of who's an alternate.
Not his name, but just.
Ms. Vortis actually still has your packets if you want to.
Software.
Yeah, why don't you go ahead and.
I say no. Yeah, I
we can
just
go
say
off the
no.
record.
Just, they need to deliver.
Okay. All right, well, let's go back on the record. The parties not agreeing or in mutual consent, then I would say that I'll just write a one-word response on here and say no and sign it and send it back with Deputy Scott. No objection from the defense. All right. And then we can get 37, 38 away and apart.
Hey, Scott, do you have a conference room? that you
Another
can-
note?
No, that's fine. Do you have a conference room that you can open up for the family? To keep them?
Yeah. That one over there, that hall is open.
Yeah, but you can keep them.
Yeah, but you full that? Yeah.
Put them
We
in
got
that,
chairs in there for you guys, got a bunch of chairs in there for y'all.
put them in that room so that you kind of keep them separate.
That is y'all room. Where your food is? that's over there.
Hello.
305 radio, equip check.
Wallace, E. Brown, and her. Who is this? Gibbs. Okay, what's wrong with it? The female? So, okay, let me get with Warren.
I'm from another courtroom. Yeah, remind me to stay out of that courtroom. All right. All right. I think the jury has relayed verbally to Deputy Scott that they want to go home. So bring them back and excuse them for the day. And I'll tell them that when they come back tomorrow morning, they can resume once they're all present. And we'll hear from them when we hear from them. So let's bring back the jury.
This doesn't have to be on the record. I have, my daughter has a doctor's appointment in the morning.
We'll figure it out. We'll go off the
I just.
when we recess for the day. We'll talk about it.
Thank you.
All right, then, Jerry. Oh, Jersey, Johnson.
All right. Thank you, Deputy Scott. Members of the jury, I've been informed that your preference is to call it a day and come back tomorrow. And so what we'll do is we'll excuse you now and we'll just give you a report back time generally as we have been of 9 o'clock, if that's what you want to do. Again, the time is yours. What I would say is don't renew your deliberations until all 12 of you are present. However, we're not going to call you back out here and say go. Once you're there, the time is yours. We'll just wait for direction from you if you have any. So before we break, please don't do any research about this case while you're not together, and don't discuss the case with anyone. Thank you so much.
Oh, you're gonna bring them in? Okay.
All right, anything to take up on the record before we recess for tomorrow?